Hi guys, am I audible to you all? Just please put in the chat box whether I'm audible to you all. I welcome you to this marathon for SBEC. Here we will be seeing what is the strategy to be applied in your subject of SBEC, considering you have very little time left. Okay, so just before I start, a small checkup whether the audio is fine. Okay, just waiting for you. Yes. Okay, great. So let's begin with the SPC marathon. First, if we go to see what is the subjects and how it is to be dealt with. Okay. First, the SBEC subject, I'm going to give a very important strategy to crack this exam and get an exemption. Okay, we are all sitting here to get an exemption in SBEC subject. So how to get exemption is what we are going to discuss. In first overview of your subject, SBEC subject, the part A is for 40 marks, 12 chapters for 40 marks. Part B, registration, license and compliances is for 35 marks, 6 chapters for 35 marks. And your insolvency, winding up and closure is your 25 marks, 3 chapters. So this is how it goes. Now this is your part A, this is your part B and this is your part C. Anytime if you see the strategy, first the objective is to finish your part B, C first, because there are only 3 chapters and 25 marks is confirmed. So our plan for the day will also be to finish part C first. There is also amendments in part C which I will also cover. So be with me. Now 3 chapters for 25 marks and there will be few questions. Remember one thing, out of 5, if you can score 4, you can easily get 20 marks here. You can get 20 marks because ye already pata hai how you can score. So always go for the easy first, then what is difficult. Certain thing ICSI gives you, take this and pass. So this we will do properly. This you have to do so perfectly and I will show you tricks where your paper can stand out and you can get 4 marks in this. Okay. Then we will do the part B, which is 6 chapters for 35 marks. And in part A, there are 12 chapters. But remember, you have already studied company law. You've already studied company law. So private company, foreign company, XYZ company, you don't need to do that much in detail. You would already have an idea of incorporation, Spice Plus form, etc. So you will be able to handle part A. In part A, you just have to do those chapters first which were not there in company law and have high weightage. For example, your NBFC. For example, your startup company. Very important chapter. So we will even try to cover those. Now, if I go to the chapter wise weightage, okay, for these chapters, okay, the chapter wise weightage, look at this. So your 18 marks, around 3 questions or 4 questions come from the various initial registration and licenses. Okay, so 6 chapters that come for 70 marks. Your CIRP chapter, your Dormant Company and Strike Off combined comes for 25 marks. So if I say part C comes for 25 marks, your licenses come for 18 marks. Okay, types of company, you will handle it from company law subject. So you will be able to manage. Okay. Then comes labor law part. Labor law is another important part which is 11 marker. Today we will also cover labor laws for you, okay, which is difficult in such a way that you will be able to score marks in labor law. I will show you tricks. There are certain tricks and techniques to handle the labor law chapter also. Okay. So I will give you that. Then comes your intellectual property rights, IPR, 9 marks, which is very important because nowadays there are lawyers in IPR. So they become IPR lawyers only. So very important field. Then is your alteration and MOA AOA, which is simple but very very important. Okay, grade 2. Then is business collaboration, which is simple, and all these chapters. Even dormant company has to come, startup company, etc. Okay. So these are your important chapters. Part C chapters are here. Okay. Though they are there, a lot of chapters, but they don't have much weightage. Now, if we go to see the paper pattern for this paper pattern, it's very simple. Okay. The paper pattern is the part C. Part C, there will be 5 questions of 3 marks each and 2 questions of 5 marks each. So the maximum marks is 5 marks in part C. So you can really score well in this particular part. Now again, if I go to the part B, in part B there will be 4 questions of 5 marks. So directly it is coming with 4 questions of 5 marks each, and then 5 questions of 3 marks each. That's your part B. So definitely you will have to find a strategy to tackle your part B, for which I am here today. Then comes your part A, which is 4 questions of 5 marks each. Lot of will be for company law, etc. and 5 questions of 4 marks each. So even this can be easily handled. So only few chapters of part A you do, part B do properly, part C do properly, your paper will go well. From your part C, if you score 20, okay, and part A you will already be able to attempt, because you already know company law and it is very simple. So here also, if you can score 15 to 20 marks, okay, you can easily clear and get exemptions from here. Now we start with your part C first, then we will go to your part B. Now I will show you all ways to get maximum marks. Many times people feel we know this chapter, etc. But the way I will tell you, the way I will show you, you will be able to stand out from the crowd and get more marks. Now I am showing what all documents I have in front of me. I have the ICSI module. You also have to get your ICSI module. Quickly we'll finish Dormant Company. Then I also have the amendment sheets. In amendment sheet, you have these chapter amendments. Okay, you have amendments in the initial registration. You have amendment in IPR. You have amendment in CIRP. That is your part C. So first we will target your part C. And in part C, from this chapter, almost confirmed PIRP will come. Almost, I feel, confirmed the PIRP will come, pre-packaged insolvency resolution process. I will show you the answers for that also. So all the 3 chapters we will do real quick. So good to go. Can we start with and I also have the past exam questions with me, the scanner. Okay. So if you want this scanner, I have put the link. You can download the app in the free section, study material free section. You will get the scanner for SBEC, which is very very important, because chapters which you can't finish, at least you look at the past papers. So many questions are repeated as well. Okay. Now let's start with the dormant company, with the concept of dormant company. Now, which sections are going to be hit and how it is to be hit? It's a confirmed short exam question that this dormant company will come. Write this down. Take a book and a pen and sit. Now, dormant company write, and write section number 455, read once. You will write this thing. In every answer of your dormant company, you will write as per the provisions of section 455 read with rule 3 to 8 of the miscellaneous rules 2014 in every single answer of dormant company, because there is only one section, section 455 read with rule 3 to 8 of the miscellaneous rules 2014. That's how you will start, and that's how impression will be set immediately. Now let's go into the concept quickly. What is a dormant company? Dormant company is an inactive company. Let me first tell you the concept real quick. So you're from here in your module, it starts from here to here is important. Now, pay attention to what I'm saying. Now, must have a piece of land. This piece of land I must be getting at a good rate. And I am thinking कि I will start my business after some time. But अभी rate मिल रहा है तो I will buy the land and keep. And the company, it will be on the company's property. So dormant company is a company can be formed for a future project. I will start my project in future. So it's a company which is set up for a future project, or to hold IPR, intellectual property rights. Means what? Today I must have developed a software. Now this software, I want to set up a software company. So I set up the software company immediately. The ultimate, I will say that this company will start functioning after some time because it is only the prototype mode. अभी खाली वो temporary mode में है. It is उसके ऊपर beta version में है. So company has been set up already. So we also have set up a software company way before it started operations. We started it. So section 455 defines dormant company. Read with, in your module you write, read with rule 3 to 8. Okay, read with rule 3 to 8 of the miscellaneous rules 2014. It says a dormant company is a company which is formed and registered under the act for a future project or to hold assets or intellectual property, and there are not going to be any significant transaction. कोई भी major transaction नहीं होने वाला है. So without any significant accounting transactions, and such inactive company has to make an application to the ROC in the prescribed forms. So now I will take you to the forms also. Again, you will take your book and pen and get it here and write with me. Okay. So these first we are hitting the particular form numbers. It's in miscellaneous rules. So the form numbers are in MSc 1. MSc form numbers. So it is MSc 1, 2, 3, 4, 5. 5 forms. So section 455 read with rule 3 to 8 of the miscellaneous rules 2014, and the forms are here. So this is the core provisions that you will quote. Okay. Now, if I am a dormant company, inactive company, I will make an application. So application for dormant company will be in MSc 1. So company will say कि भाई I am going to be dormant, मुझे strike off मत कर देना thinking I am खोका shell company. Don't think that I am a shell company. I am a inactive company. The reason is I will start my operations after some time. अभी company खोल के रख दिया है मैंने. खोका company नहीं है, project चालू होगा. Project will be started. It's not a shell company. So then I make an application. ROC will say fine, okay. Then ROC will grant you the status of a dormant company. It is in MSc 2. I make an application, company makes application in MSc 1. ROC grants the certificate of dormant company, status of dormant company in MSc 2. MSc 3, then I will say, oh fine, great, I am a dormant company. With dormant company, I am relaxed, enjoying. Then ROC will say, come here, come here. You are a dormant company, but you have to file returns. Keep filing returns. So I made an application, ROC gave the certificate. Then I'm going, ROC calls me back and says, keep filing returns. I say fine, returns file karunga. Then I will make an application for seeking the status of active company. Now, जब company वापस active हो गई, now मेरा project is all good to go, it's ready to start. Then company will make an application for seeking the status of active company, and ROC will give a certificate of status of active company. Till here, absolutely clear. So, okay. So what is a dormant company? A dormant company is a company which is formed and registered for a future project or to hold a property or intellectual property rights, which is not going to have any significant accounting transaction. So there are not going to be any significant accounting transactions, and such company is an inactive company. Now, what do you mean by inactive company? Inactive company means a company which is not carrying on any business operations, which does not have any significant accounting transactions, and which has not filed annual returns or financial statements for 2 years. I want you to perfect it with me now so that whatever 5-mark question is asked, 6-mark question is asked, you get full. So you will say it is an inactive company. How we say it is inactive? First, does not have any business operation. Second, it is not having any significant major accounting transaction nahi hai. And third, it doesn't have any filing any financial statements or annual returns for 2 years. Now it says that what do you mean by significant accounting transaction? They can ask you. Significant means what? So I will say any transaction other than all those transactions that you're paying to the ROC for maintaining the company, just general routine statutory fees भरना doesn't mean कि तुम business कर रहे हो. So just if I have a transaction of paying ROC filing or making the return, so doesn't mean I become doing some major transaction. So if a company doesn't have any significant accounting transaction, it's a dormant company. So any transaction made by the company except transaction mentioned below. So all these are small transactions. All these are small transactions. So payment of fees to the registrar, payment by the company to fulfill the requirements of this act, allotment of shares, and payment for maintenance of its office and records. So these are no significant accounting transactions. So all the transactions apart from the above will be considered as significant accounting transaction. ये सब के अलावा all other transactions will be treated as significant accounting transaction as per section number 455 read with rule number 3 to 8 of the company's miscellaneous rules 2014. It gives you the definition of dormant company, a company made for future project or to hold assets which is not going to have any significant accounting transactions. Such company will make an application in MSc 1. The certificate will be granted in MSc 2. Company has to file returns in MSc 3. जब एक्टिव हो रही होगी तब MSc 4 का एप्लीकेशन फाइल करेंगे. दैट बॉस आई एम गोइंग टू बी एक्टिव नाउ MSc 4. ROC will say fine, now you are going to be active, take MSc 5. Clear till here? They've given what is inactive company and they've defined that. Now in your in the section 455 there are 6 subsections. Okay. So one of the subsections, if I just take you through, so 455 has 6 subsections. Now the first one says that you can make an application, okay, a company formed and registered for a future project or to hold any intellectual property which has no significant accounting transaction is given. So you can write the definition is under section 455 subsection 1. Then comes suo motu application. The company can make an application to ROC. Application to ROC that will be in MSc 1. Certificate will be granted in MSc 2. This is given under section 455 subsection 2. Company makes application to ROC. Third, whatever details we give, ROC will maintain a register of dormant companies. Now, section 455 subsection 4. I want you to pay attention to this. Section 455 subsection 4. कोट करने का ना सेक्शन सबसेक्शन के साथ कोट करेंगे. 5 में से 5 चाहिए मतलब चाहिए. ओके, सो राइट इट डाउन विथ मी. इसके बाहर का कुछ नहीं आएगा. ठीक है. इन 455 subsection 4 says ROC identifies such companies which are dormant and then tells that you are a dormant company and it will give a notice to such company. See, ROC classifies. मैंने application नहीं किया, मैं dormant था, इतना inactive था कि dormant company के status के लिए भी apply नहीं किया. So ROC classifies a company which has not filed financial statements or annual returns for 2 financial years consecutively ROC will issue a notice to such company and enter the name of such company in the register of dormant companies. So any company which has not filed, so ROC classifies a company as dormant when for 2 years they have not filed annual returns or financial statements. Till you're absolutely clear. Write the subsections also. There are 455 has 6 subsections. I am telling you to remember subsection 1, subsection 2, subsection 4. Then compliance is that a dormant company has to that a dormant company has to follow some things. One we had done. Remember, if I get the status, I'm very happy that I'm a dormant company. ROC will say, come here, come here. Maintain returns. MSC 3 file returns. I say, okay, I'll file MSC return. Then they will say, maintain the minimum number of directors as given. What is the minimum number of directors? So for it is 1, 2, 3. 1, 2, 3. 1 is for OPC, 2 is for private company, 3 is for public company. So this is the minimum number of directors dormant companies have to maintain. Okay. Then if a company wants to, it has become active, it has started doing activity. So the directors will give a letter to the ROC within 7 days of any act in which they have become active. That we have become active, please give us the status of active company now. Registrar shall strike off the name of dormant company if you have not become active in 5 years. Now tell me one thing, can I become inactive company for lifetime? No. Maximum कोई तो time period होगा ना, the maximum time period that is 5 years. Okay, so 6 subsections is there. Yeah, subsection again. Subsection 1 is the definition. Write it down with me. Quote it in your examination with subsection. Sections 455 subsection 1 gives you the definition. Section 455 subsection 2 says that company will make a application in MSc 1 and MSc 2 में certificate मिलेगा. MSc 3 में जब certificate मिलेगा, ROC will maintain a register of dormant companies. MSc 4 is when ROC will identify companies which for 2 years have not filed financial statements or annual returns and put them under the dormant company register. And compliance is given under 455 subsection 5, which says that to maintain the minimum number of directors and file returns under MSc 3. And 6 says that boss 5 years time limit मिल रहा है. If 5 years में नहीं मिला, we will strike off. We will remove your name from the register of companies and we will go forward to dissolve the company, end the company, wind up the company. ठीक है? Prerequisites for this thing, मतलब अगर करना है तो प्रोसीजर क्या है? तो एक स्पेशल रेजोल्यूशन लेना पड़ेगा. कोई there should not be any inspection, cases, defaults, taxes or any loans on that company. Then only the status can be given and it should not be a listed company. So today if my company has a loan, if my company is under default, any inspection, an inspection section, write it down with me, section 206, we will show off the sections in the examination. Okay, and I will give you, all you need to do is with the lecture you need to write the section and subsection with me जो मैं बोल रहा हूँ. Inspection is conducted under section 206. If inspection is there under 206, it cannot be done. So no inspection, cases, defaults, taxes, loan should be there. It should not be a listed company and you should pass a special resolution. All these things are, if it is there, only then you will get a status of dormant company. Now let's go next. Obtaining the status, we said, and now you have to tell me which subsection this is. Obtaining the status of dormant company, suo motu application. Company will make an application under in MSc 1. Which section, subsection? Please put section 455 subsection 1. that you will make. Dormant company by ROC. Which section is this? Which subsection is this? Classifies a company as dormant company. So you have your section 455 subsection 4, where if a company has not filed financial statements or annual returns for 2 years consecutively, continuously, then ROC will give a notice and enter that company's name in the register of dormant companies. Okay. And I told you this last part. Very good. Perfectly all answering. Now section 455 subsection 6, only 5-year time limit is there. So the registrar shall initiate the process of striking off if the company remains dormant for a period of 5 consecutive years. So अगर 5 साल में एक्टिव नहीं हुए तो then आपको strike off कर देंगे. Then we will strike off. Now again they have repeated all of this legal framework. Application for dormant company and by applicant, and it is by ROC. Now under applicant is under section 455 subsection 1 and by ROC is under section 455 subsection 4. Please quote the subsection, you will stand out from everyone else. And before the end of the financial year, you have to change, before 5 years end, you have to change from dormant to active. Now going ahead to the procedure for obtaining the status of dormant company. So this is also important. Every single thing that I am discussing is coming in the exam, and from here only top question will come because I am covering everything. ठीक है, तो शांति से सुनना, एग्जाम का क्वेश्चन आएगा यहाँ से. Procedure. Now what is the procedure? You tell me. So first I will write the section 455 read with rule number 3 to rule number 8 of the miscellaneous rules contains the provisions with respect to dormant company. The procedure is laid down as below. अब मैंने बोला था कि special resolution लेना है. We have to pass a special resolution. So remember, yes, 455 subsection 1 में definition है. Definition भी है और form numbers भी है किसमें apply करना है. Now the company shall fix a board meeting. Now if you want to stand out more, write that the board meeting, you all have studied company law, under which section is notice of board meeting given. Put in the chat box which section you all are becoming company secretaries. Which section for board meeting is there? Section 173. Okay. So remember this section, write it down. Okay, write this down. It is a board meeting. So a notice is to be given to the directors under section 173 to convene a board meeting. After the board meeting is there, then proceed to call a general meeting. General meeting ka notice is under section 102. 102 you will give a notice of general meeting. Along with that you will add a explanatory statement under section 103. All this you write, your paper will stand out. Okay, obtain the status of dormant company. Next, एक बार ये हो गया. Okay, you take a special resolution. Then comes ROC will say na that you want to take a dormant company, so give me your account, call an auditor and give me that. So the company shall obtain a statement of affairs from the auditors. The statement of affairs shall give the financial position at the time of passing a special resolution. So you have your statement of affairs from the auditor. So I am writing the auditor's certificate you require. Then the company shall hold a general meeting and pass a special resolution. By default, whenever you pass a special resolution, you have to file MGT 14 for special resolution with ROC within 30 days of the resolution. Fine. Next, after filing MGT 14, the company shall file MSC 1 and ROC will give the certificate in MSC 2. So what is the procedure? Procedure is special resolution, auditor certificate. Then after the auditors have given the certificate, then I will pass this MGT 14. I will file MSC 1. ROC will give certificate in MSC 2. Now coming to prerequisites for obtaining the status of dormant company. Mark it as super important. It has come in the exam. Prerequisites are done, right? सब कुछ सेम है. Prerequisite क्या है? पहले एक special resolution is required. Remember we have done that. That is a requirement. Now if there is any investigation, inquiry, pending court case, तो कैसे स्टेटस दे देंगे तुमको? डॉर्मेंट कंपनी का स्टेटस, अभी तो केस चल रहा है, कंपाउंडिंग एप्लीकेशन का केस है. तो रिमेंबर देयर आर all these points. So I'm highlighting the important points. So any inspection, inquiry, investigation is carried out against the company. Put in the chat box what is the section for inspection, inquiry, investigation, because we will quote सामने से section 206. Any prosecution is pending, कोई केस पेंडिंग है कंपनी के अगेंस्ट, so you cannot obtain the status of dormant company. These all things are prior requirements कि ये सब नहीं होना चाहिए तो ही स्टेटस मिलेगा. There are any public deposits outstanding and the company is in default in payment. So if you have defaulted in payment, in loan it won't be there. Next, there is any outstanding loan, whether from secured or unsecured. In case the company has any outstanding loan, the company must apply for the status of this after taking the approval from the lender. Pay attention. What is this? That if it has any outstanding unsecured loan, company has to take a NOC from the approval from the lender. Now I'll show you how exam question it was framed. Okay, first let me finish. Then comes any outstanding loan. Then you require a NOC from the lender. No dispute between the management should be there. Okay, and any outstanding taxes, dues, duties should not be there. They should not be in default in employment, workman dues, and it should not be a listed company. So what is it? Quickly, what are the prerequisites? How many points do you remember? So first, no investigation, no prosecution, no public deposit default, no outstanding loan. अगर loan है तो take a lender's NOC. Dispute नहीं होना चाहिए, taxes pending नहीं होने चाहिए, workman dues pending नहीं होने चाहिए, and the company should not be a listed company. Okay, what is the meaning of the word prerequisite? So prerequisite means conditions. Requisites means requirements, prior requirements for obtaining the status of dormant company. So these requirements have to be ensured, only then you can get the status of dormant company. Now let me take you to one of the few exam questions and see how the answers and questions come up. Okay, see what is the question. Now these are exam questions what they have asked in the past attempt. Company has not filed annual financial statements and this for the last 2 years. Wants to seek your status for the approval. Company has approached you seeking your advice for the benefits. Abhi aayega. I'll show you what situational question I wanted to show you. See this. Last attempt they have asked this question. Just in the last attempt, that a company is not carrying on any business for 2 years. Okay, they want to make an application for dormant company. One of the directors said that they have an unsecured loan from the creditors. The company cannot obtain cite the relevant sections and explain if whether the director's statement is correct. So what we will say, yes, section this read with rule 3 to 8 state that if there is any outstanding loan, then you require a NOC from the lender. Approval of the lender is there, therefore the director's opinion is correct. Moving ahead to the next exam question that they have asked, what is the benefits and exemptions provided under the dormant company? फायदा क्या है dormant company का? चलो बताओ, what is the benefit of dormant company? So very first thing, I can hold the asset and the intellectual property without being an active company. तो वो एक benefit है. तो ये रहा. Okay. They will be able to be a dormant company. They can so let's go in order only. Dormant company है तो logic लगाना. See now, pay attention to the logic. If I am a dormant company, there is not going to be any major transaction. तो meeting करके फायदा क्या है? In board meetings, section 173, you require 4 board meetings in a year, right? You require 4 board meetings. तो ये तो 4 board meetings करेंगे ही क्यों? So dormant company के लिए benefit दिया हुआ है that a dormant company shall hold only one meeting in half a year. Only one meeting in a half year means total 2 meetings. Only 2 board meetings in a year with a gap of 90 days in between 2 board meetings. Now जब transactions ही नहीं होने वाले तो cash flow statements देने की क्या जरूरत होगी? They are not required to maintain cash flow statements. Next, provision of auditors rotation is not applicable. They enjoy lower statutory compliances since they don't have to hold annual general meeting. So cost will be very less. Then dormant company is an advantage to the promoters who want to hold intellectual property and they are holding it for a later stage. They can enjoy the status of dormant company for 5 years and they will not be liable to pay any taxes until they require the status of active company. So quickly, what is the benefits? So first benefit I can see from your, what do you think is the most biggest benefit? दो ही board meeting रखनी है. Come board meeting, if there are lesser board meeting means lesser compliance cost. If there is not going to be any transaction, there is not going to be any requirement to give a cash flow statement. Provisions of auditors rotation. Auditor is there, but why do I need to rotate the auditor? Rotate means change the auditor. एक ही रखो ना, transaction वैसे ही नहीं हो रहे. Transaction are not happening. So provisions of rotation of auditors is not applicable. Next, dormant company is at an advantage. So you can hold intellectual property rights and hold assets, and the company can begin its operation at a later stage. This is the benefit. For 5 years you can be dormant. You don't have to pay any taxes since you are not going to have any business, and it is easier for the dormant company to get the status of active status. So active के लिए कौन सी forms file करना है? MSc 4 and 5. Very good. Now compliance requirement by the dormant company. So tell me one thing, if I am a dormant company, मुझे certificate मिल गया in MSc 2, can I start dancing and say I don't have any obligation? They will say what nonsense. The ROC, what are the compliance requirement for dormant company? एक ROC के ऊपर compliance requirement है. That is that ROC has to maintain a register, and this if you go to see, it is given in your section subsection 3, 455 subsection 3, that the ROC will maintain a register of which all companies are dormant. Then comes dormant company will have a minimum number of directors. So minimum number of directors is for 1, 2, 3, 1, 2, 3. 1 is for OPC, 2 is for private, 3 is for public company. Then I told that they have to maintain a return. Return at least has to be maintained and filed by them in MSc 3. Okay, we did that. Then comes, they do not have to enclose any cash flow statements. They will have to convene at least one board meeting in each of the half year. See, they have also quoted section 173. You all are babies, so I am not giving you subsection for company law. At least you can remember section 173, board meeting, and board meetings also has to be done half yearly. Notice of board meeting, all is given under 173. So quote that. Provisions of the act in relation to auditors is not applicable. Rotation of auditors not applicable, and the company shall continue to file the returns of allotment, change in directors, wherever it is needed. Okay, so this is there. Now coming to the next thing, legal framework dealing with the provision for seeking the status of active company. तो भाई हम लोग ने बोला था एक्टिव कंपनी के पहले फॉर्म बता दो फटाफट. What is the provision for active company? Come on. This if you don't know, really you should know. 4 and 5. MSc 4 में application दो, MSc 5 में हम लोग को certificate मिलेगा. Okay. So here they are going to say MSc 4 and 5. Very important. Can you see this? Procedure for obtaining the status of dormant company. MSc 4, MSc 3 they have to file returns, and MSc 5. So you can quote it in your own words. But one important line I want to bring to your notice. Very important. ये एक line मैंने starting of the lecture में बोला था. I told this line in the start of the lecture. But see this. That you will get within 5 years they have to get active. and application will be made for active in MSc 4. Certificate for active company will be given in MSc 5. Perfect. Now this part, the registrar. Now this is important. 7 days time, something like a 7 days time. Moreover, if the company uh, has contravened any of the conditions in the grounds for application of the status of the dormant company, the director shall within 7 days of the contravention file with the company for obtaining the status of active company. What is the meaning of this? Can you all tell? That means if the directors of the company have found that the company has now begun the operation, it is the duty of the directors within 7 days of the contravention. That dormant company is given to subject certain conditions, you have to give it up. So within 7 days of the contravention, you have to file a status of active company. Okay, now let's see. I believe the screen is flickering. Let's see, it shouldn't be now. Let's continue. If it still flickers, I will stop. We are almost to the end of the chapter. I want you to get full marks. Full marks. Okay. Now the ROC shall in the following cases change the status of the dormant company to active. Dekho. When the ROC, now this is a hidden question. Okay, they can ask you when the ROC will change the status of the dormant company to active. One, if application has been received in MSc 4. So they will give you about application in MSc 4. Okay, MSc 4, if we receive a application, we will make it active. Second, if the directors have notified us, director ने बताया, notify किया that we have violated some of the conditions for dormant company, please make us active, or we have become active again, so please make us active. So listen to this. So where a dormant company, okay, omits any of its ground in the application made for obtaining the so whenever a dormant company violates a condition for obtaining the status of a dormant company, the director shall file an application within 7 days from the event of obtaining the status of active company. For the status of obtaining the status of active company means what? Directors found that we started becoming active again. So within 7 days, they have to make an application for making it active. Otherwise, if nobody is making application, ROC also has suo motu powers, where the ROC has reasons to believe that any registered company as a dormant company has started functioning. Okay, then the ROC will initiate the proceedings for inquiry under section 206. I told you, inquiry section 206, you have to put in the exam. Then they will do an inquiry, they will give an opportunity to being heard, and if it is found that the company has actually become active, then the ROC can remove the name of such a company from the register of dormant company and treat it as a active company. With this, I have completed the full chapter from the module. No question will come outside this. Okay, so 5 marks, I want you to score 4 marks minimum. Okay, let's go to the exam questions also, what all has been asked, and I want you all to keep putting in the chat box. Okay, listen what all questions have come. This is in December 2020. If you want this sheet, download our app, Jahangir Tutorials app. I've put it in the description also. There in the free section for notes, you will get these notes. Dormant company stated is an excellent tool for keeping the assets for its future usage. Explain. So we will say, as per section 455 read with rule number 3 to 8 of the company's miscellaneous rules 2014 provides for the or contains the provisions for dormant company. A dormant company is an inactive company. Here the company is formed for a future project or to hold certain assets or intellectual property. and is not going to have any significant accounting transactions is a dormant company. Application will be made in MSc 1, certificate will be granted in MSc 2, returns will be filed in MSc 3. MSc 4 is when an application to become active again, and certificate of active company is given in MSc 5. Now see how they have written. A dormant company means a company, you will give the definition. Then here they have given in their own words also. A company offers excellent, because यही language use करना पड़ेगा ना. General question है तो वो language से थोड़ा connect करना पड़ेगा. That are direct promoters who want to hold assets or intellectual property as a corporate shield for a later date. Like I told you, a software company that I have formed, I'll form it now, even though it is in a beta process. No significant accounting process will go on. We all are doing R&D only, but company में बना के रख दिया. For instance, if a promoter wants to buy a land now for a future project, because it is at a lesser price, he may same do so with the help of a dormant company. So done. Next is, which I explained, that there was an unsecured loan. So since there is an unsecured loan, in the prerequisites, prior requirement, it is stated that if there is an unsecured loan, consent NOC from the lender is required before filing MSc 1. Then the next December 2021 question, they have given you a situational question. Now pay attention, okay? Krishna Private Limited, having 3 directors, obtain the this of dormant company. They seek our advice about the compliance needed to be done in respect of each of the following. One director, he is also a shareholder holding 10%, wants to retire from the post of directorship and wants to transfer his entire shares. Second, the minimum number of directors. So minimum number of directors is directly given. Okay, a dormant company shall have minimum number of directors as given, which is 1, 2, 3. Then with respect to the third point is rotation of directors, the provision of rotation of directors is not applicable. Now the question is, they've asked कि ये तो निकल गया भाई साहब, रिटायर हो रहा है, उसको छोड़ना है, तो क्या रहेगा, करना है कि नहीं? So we will say, listen, the provisions of allotment of directorship will have to be filed normally as it would have been filed here. See, a company shall continue to file the returns of allotment of change in directors even if it is a dormant company, wherever the company allots any security to any person in change. Further, in case the director wishes to transfer his shares, he may do so subject to the compliance of the articles of the and the Companies Act. मतलब ये किधर लिखा है मॉड्यूल में? If you go to see here, see, they will continue, the provisions of this will continue. So with respect to, so this is in the past exam question, from this chotu sa line they picked up. See, from here, this one sentence from here, they picked up a situational question. A dormant company, where it was given in the compliance requirement. Okay, so mark it as important. 2-3 times they have asked from this table only. What they've asked, that a dormant company shall continue to file returns of allotment, change in directors in the same manner as specified under the Companies Act 2013 and subject to the provisions of the Articles of Association. Okay, company allots any security to any person or there is a change in directors, you have to comply with the Companies Act. That is it. I believe we've covered with all the exam questions. This is direct question is, what is the benefits or the exemptions provided toward dormant company. So same points, benefits, only 2 board meetings, compliance cost is less, they can hold it for 5 years, then lower statutory compliance cost, no cash flow statements to be given, provisions of rotation of directors is not applicable to the dormant company. So that is it. I believe we have covered with all the exam questions. Now the next chapter that we will be doing is striking off and restoration of name. Let's look at the 25 मार्क्स में से 20 लाना ही है. Out of 25 marks, 20 you have to get, and that will be enough. You will be able to score. Okay. And just one thing, is my audio and video clear or it is hanging? Is there a lag or it is proper? थोड़ा lag हो रहा है या बराबर है? Just put in the chat box so I know. Is my audio clear? Okay. Now we are doing the next part. Okay, great. Okay. Now the next we are seeing is your striking off. The next chapter we'll be doing is strike off restoration of name, that is for 10 marks. So two confirmed questions are going to come. This is from striking off chapter. Strike off chapter. So this will be, so this we have completed, and this you have to give a commitment that you will get maximum marks here. Okay, 6 में से तो fully लाना है. Dormant we are done. Now we are going to do striking off and restoration of name. After that we will do this chapter CIRP, from which PIRP is there. It's a new concept. Confirmed PIRP will come according to me. Okay. So now we'll be starting with the restoration of name. So let me just set it up. Strike off, and restoration of name. So this chapter we will start. I want you to revise. So finish part C with me. I don't take too much time in the sessions. I quickly finish. Okay. So you can finish with me. Whatever I'm doing, I'm going in order of importance. 25 marks I'm going to finish perfectly. So finish it with me. Now striking off also I will start. We will take a short break. You need to revise your striking off chapter from whatever you know, or finish off your Dormant Company in case you are not done. We'll take a short break. We'll return at 2 p.m. and we'll finish this striking off chapter. So we have a break. Your job is to revise this strike off chapter. So after part C, I will jump to part B. So take at 2 p.m. we return. Clear till here, and just inform your friends if it is not there. Yes, it's for small companies. PIRP is for small companies after COVID they have got. So wait for that. I will cover that in the 21st chapter also. Okay. So we are taking a break. We will start this striking off and restoration of name at around 2 p.m. Okay. So that's it. See you all at 2 p.m. Hi guys, am I audible to you all? We'll quickly finish with this chapter also. Am I audible to you all? Just put in the chat box. Hmm. Just put in the chat box if I'm audible, and we'll quickly start with all the past year exam questions. And great. So we will cover all the past exam questions, and now we will confirm that we get 10 marks confirmed. Okay, it's a 10 to 12 mark chapter confirmed in your examination. Okay, so we will finish that also for compliance. Because I'm just seeing the exam questions. Okay, great. So we are starting. I hope you all have this sheet. We'll be doing all the questions in this also. Explain the situation in which cannot strike off. Very good. And all the questions done. Okay, so 10 marks full we have to get. So we will learn in a way that we can score extremely well. Okay. चलिए. So these are the exam questions. Okay, so again, now whenever I'm starting a chapter, I want you to take a book and pen and make short summary notes of the key points, key highlighters, key those cherry on the cake which will decorate your answer really well, like the section number, rule number, form number, all those things. I will give you the technique to remember that, and you will go and show off in your papers. Okay, chaliye. Let's think positive that we will know all the sections, all the subsections, everything will come from what we do. So let's begin with the striking off part also. Good to go. Can we begin? I just need a thumbs up and we begin quickly. I need a thumbs up from you and we start. Okay, so let's begin. Hi. So we'll be starting with the striking off and restoration of names under the Companies Act. This chapter alone has a weightage of 10 to 12 marks confirmed in your examination. So we will be beginning with the provisions of striking off. First, before we start with the concept of striking off, let's understand the meaning of the term striking off. Striking off simply means that to remove the name of a company from the register of members. So whenever the registrar of company has the power to remove the name of the company from the register of members, from the register of companies. So it is the removal of the name of the company from the register of companies is called as strike off. Okay, is called as strike off. The provisions of striking off is the main provision is covered in your section 248 of the company law. So what is section 248 subsection 1 and subsection 2? Subsection 1 talks when the ROC suo moto on its own identifies companies which are not functioning, which are defunct, which are inactive and not got the status of dormant. So जो भी कंपनीज फंक्शन नहीं कर रही है उसको उड़ा देंगे, उसको स्ट्राइक ऑफ कर देंगे, उनका नाम रिमूव कर देंगे. So this is when ROC strikes off suo moto on his own account. Okay, so this is the power of ROC to strike off suo moto. Take a book and pen and write down section number 248 subsection 1. In this, ROC will give a form, STK forms, STK form number 1, ROC will use. Okay, this is your section 248 subsection 1. Second, if sometimes company themselves realize I might have set up a company, now I feel that there is no business opportunity and I have started diverted my focus in other business. So this company, I can tell the ROC by making an application myself only that this company is no longer going to be functioning. You only strike it off. So I inform in section 248 subsection 2. So here the provisions will be, the form number will be in STK2. Clear till here? Here the company itself tells the ROC that you shoot me, you kill me, you finish it off. Okay. So again, if they ask what is the procedure for striking off of company by ROC, suo motu, ROC itself, so it will be 248 subsection 1. But if they say that the company has now decided to tell the ROC to kill it, कि आप मार दो मुझे, you delete my name, you remove my name, so that will be under section 248 subsection 2. Now before we start, I want to take you to the form numbers. Okay, so let's read the provision. Section 248 is the main provision for striking off. Okay, now let's see subsection 1. Who initiates the striking off in subsection 1? 248 subsection 1. Who initiates the striking off process? Quickly, who strikes off suo motu? I want you to put in the chat box. Whatever I do, from there only it will come, because I'm going to cover everything. So it is the ROC. So when the ROC has reasonable grounds to believe, जब ROC believes, has reasonable grounds to believe that a company, okay, where the ROC itself has reasonable grounds to believe that it has failed to commence the business. तो commence ही नहीं करा business within 1 year of incorporation. Incorporation हो गया, commence ही नहीं किया. Second है, next point, a company is not carrying on business for 2 years preceding the financial year and has not made an application for Dormant Company. एक है कि आपने incorporation के बाद चालू ही नहीं किया, commence ही नहीं किया from incorporation, from birth. 1 year हो गया, so ROC will give a notice and strike off. Second, हो गया incorporation और suddenly आजकल companies कोई भी realize किया 2 साल से बंद है. So for 2 immediate financial year they have ceased not carrying on business operations. So ऐसी companies को identify करके, और अगर वो कंपनी ने डोमेंट का स्टेटस नहीं लिया, अगर कंपनी नॉट टेकन डोमेंट, देन वी विल स्ट्राइक इट ऑफ. दिस इज द सेकंड. थर्ड इज अंडर सेक्शन 10A. अंडर सेक्शन 10A टॉक्स अबाउट कमेंसमेंट ऑफ बिजनेस. एक डिक्लेरेशन होता है विद द डायरेक्टर्स हैव टू गिव विदिन 180 days. ओके, सो इफ द डायरेक्टर्स विदिन 180 days have not given the declaration for commencement and the subscribers have not picked up their subscription shares, so the subscribers to the MOA have not paid the subscription under which they had taken to pay at the time of incorporation, and a declaration to that effect is not filed within 180 days from its incorporation. So 180 days from its incorporation, subscribers have to pick up the shares, take it, and the directors have to give a declaration. Only then we will say you can commence the business. तो वो भी नहीं करा. And third, you're not carrying on any business operations as revealed after physical verification. तो अगर हम लोग ने जाके place में देखा and we did not find and in your registered office that you were there, so in such case we will strike you off. Now, so what is the first case? Pay attention, write it down. Section 248 subsection 1. They have given you a total of 4 conditions. 4 conditions. What are the 4 conditions? First condition, from 1 year has passed and you haven't commenced business. Second, your incorporation के from incorporation 1 year has passed and not commenced the business. Second is any time for 2 years consecutively you've ceased to commence business operation. Third, the subscription shares and the declaration is not being given within 180 days from the date of incorporation as given under section 10A, which is commencement of business. And lastly, after physical verification of the premise, we came to know you're not functioning. So then in such cases, the ROC will give a notice in STK 1 and after all the procedure will strike you off. Second, subsection 2 says that about the company itself finding that we should strike it off. So, so if a company after extinguishing its liability, this is when the company does. So this is company suo moto makes application. Suo moto makes application. They only make an application, they pass a special resolution. Okay, 75% of the consent have done, they have removed all their liabilities, they do all the necessary forms, and then they tell the ROC that you strike me off. Is this clear? Till here is this much clear? 248 subsection 1 and subsection 2. Your company by passing a special resolution, company passes special resolution and says that strike me off. Your ROC for 4 conditions. What are the 4 conditions? 1 year of incorporation is done and business not commenced. Second, from 2 years you have shut business operation. You've shut business operations. Third, your subscribers have not picked up the shares. And fourth, what is the fourth point? Put in the chat box. What is the fourth point? Quickly put in the chat box. What is the fourth point when the ROC has the power to strike off? So whenever he strikes off, he will has a form which is STK1, and your company, if they tell the ROC that you strike me off, this will be in STK2. What is the fourth point? Quickly, let's see if you all tell. So 1 year for incorporation and business not commences, 2 years, perfect point. Physical verification. On physical verification, we came to know that the business was not commenced. Now this physical verification exam mein question aaya tha. We'll show you also. Now again I want you to write down these form numbers. These form numbers because this will help us show off in the exam. Okay? Very good. Now first form is in section 248 subsection 1. 248 subsection 1, that company, the ROC will identify on those 4 conditions कि भाई ये company function नहीं कर रहा है, इसको STK1 form से notice भेजेंगे. So ROC will send a notice in form STK1 inquiring from the directors that are you commencing business? Have you done these 4 things? It will wait for 1 month for their reply. Then the ROC will also inform all the other regulatory authorities. तुमको पता है क्या? Did you know? Did you know? We will ask all the authorities, and then after that we will pass, after hearing all the parties, it will pass a striking of order. Till here it is clear. Section 248 subsection 1 and STK1. Now when the company is filing, company itself is saying आप मुझे उड़ा दो, STK2 आप मुझे उड़ा दो. So this will be under section 248 subsection 2. In that, more number of forms. Company क्यों बोल रही है उड़ा देने को? Why is the company saying? We will tell the director, get an affidavit on paper, write that you are telling that you don't have any dues. Get an indemnity bond. Indemnity bond means what? That in case if there is any loss, you will indemnify, you will repay. Indemnity bond sign कराएंगे, affidavit sign कराएंगे. In all cases, public advertisement is done. Till here it is clear. When the company makes this application, it will be along with the indemnity bond and affidavit. Indemnity bond is where directors are saying that in case if there is any loss due to this striking off, we will indemnify. Here affidavit that all the investigation has been, everything has been done and it is not used to defraud. So pay attention. These 3 points go hand in hand. समझ में आ रहा है? ये 3 points hand in hand जाते हैं. अब 248 subsection 1 का notice is here. So this here I want you to write the form numbers. We have to remember it. Provision is very simple. ये फॉर्म नंबर्स याद नहीं रहते और एग्जाम में पूछ लेते फॉर्म नंबर्स, तो एक साथ ही पढ़ के ऐसा वी विल राइट विद सबसेक्शंस. 248 subsection 1, 248 subsection 2, STK 1, STK 2, we'll write everything. Now STK 1 के लिए notice in the newspapers will go in STK 5 and a English newspaper will be in STK 5A, public notice. Till here it is clear. STK 1 is when ROC gives a notice to the company that we are planning to strike you off. Tell us why we shouldn't strike off. Then ROC will make a public notice under section 248 subsection 1 only. So these two are in hand. So STK 1, STK 5 and STK 5A will go in hand. Now we are talking of these 3 forms. When the section 248 subsection 2, 248 subsection 2 में क्या है? Company is telling that strike me off. So STK 2 फाइल होगा. भाई indemnity bond भी दो साथ में. Indemnity bond में कुछ गलत हो गया, you will be held responsible. And STK 3 affidavit, इसका notice, ये तीनों का public notice will be in STK 6. This will be in STK 6. See, this is for 248 subsection 2. This is connected with STK 6. Then once it has been struck off and for dissolution, this is the time when the company ends. Wind up, closing, shut down. Company is ended. Section 248 subsection 5. In this point, a notice of striking off and dissolution is there. Means at this point the company no longer survives. It is the end of the company. So we will quote every single form number also. Clear? STK 7 is a common form that when it is a notice for dissolution, it will be in the very last. Chalo, now let's go from the module quickly and finish it off. ठीक है? इतना ही important है, फिर एग्जाम में देखते क्या क्या है. Now the ways of striking off. So whatever I'm doing, only do that much. You can do more if you want, but I'm covering all the main points. Most of the time things are repeated. So I will go only to the main part which will be easy for you. Okay. Now you all have to put in the chat box, suo motu by ROC is under section 248 subsection 1 is by ROC. 248 subsection 2 is by an application by company. So company initiates the striking off. Till here it is clear. This you can skip because it's going to come down. Here. Strike off by ROC suo motu. Now if it is possible, we will also quote the rule number. Section 248 subsection 1 read with rule 3. So 248 subsection 1 we will write it is as per rule 3. 248 subsection 1 is as per rule 3. Okay, we will quote. The ROC can suo motu remove the name of the company in 4 cases. In 4 cases they can remove. What are the main ones? If you have failed to commence business within 1 year of incorporation. Second, if for 2 consecutive years धंधा बंद कर दिया अचानक. Okay. Okay, just a sec. Okay. Yeah. So now fail to commence business. Second condition is not carrying on business operations for immediately 2 preceding financial years and you have not applied for the status of dormant company. Third, the subscribers have not paid up the subscription money. Okay, and a declaration by the directors that they are going to commence the business and taken up the subscription shares is not being received within 180 days. ROC will give each one strike off. The company is not carrying on business operations as it was revealed after physical verification. So when ROC has a power to physically verify whether it does it through professionals. Professionals go and see that ये तो business ही नहीं है. So then in that case they can strike off. The notice will be sent in STK1. Procedure is very simple. You can remember the head points. Okay. Let's see. First, what is the notice? First, ROC will give a notice. It will be given in STK1. Company will get a 1 month's time, 1 month's notice to reply. Second, after considering the reply, company will get a chance to reply. Then a publication of notice will be done. Can you all tell me in which form number publication of notice will be done when it is by ROC? Put in the chat box quickly, because in exam we will write section, rule and forms. STK 5 and 5A. Then ROC will also inform the authorities that it will tell the authorities, income tax, different authorities, sectorial regulators like RBI, SEBI, and the ROC will say, तुझे पता था क्या ये function नहीं करता है? They will ask that, did you know that they are not functioning? Do you have any objection if I strike off? All those things. Okay. Perfect. Okay. Then comes removal of the name. After hearing all the parties, they have a right to remove the name. Sixth is realization, provision for realization of amount due. Now ROC has to see that अगर कुछ पैसा है तो proper provision होना चाहिए for realization of the money due. And one very important point, remember, if ROC has struck off a company, does that mean that the liability of the directors and the members is also struck off? Members और इसकी liability भी खत्म हो गई क्या? Company खत्म हो गई, but liability will continue to remain. So the directors and the members' liability will always remain with respect to when the company was in existence. What liability it had, ROC just removed it, but the liability will always remain. And seventh, notice of dissolution will be given that the company has been dissolved. Can you all put in the chat box which is the form number for notice of dissolution? Quickly. We will quote in the exam. Okay. Section, rule and form. 248, rule 3, form STK 1. 5 and one more. Which is the last form? Quickly, I need your help. That is STK 7. ठीक है, लिखना ही है एग्जाम में. So notice will be given, then wait for the reply. So notice will be given in that STK1 form, then you have to wait for 30 days for their reply. Perfect. Consideration of the representation, then we will listen, consider. Publication of notice in STK5. Okay, and publication in English language, it will be in STK5A. Intimation to the regulatory authorities, very important. ROC will inform the regulatory authorities such as income tax, excise, service tax, GST officers ki, do you all have any objection? If you all have any objection from striking off, please let me know. Is there any dues left? Striking off or removal from the name of the company after 30 days from the notice of the letter of intimation. If there is no objection within the 30 days from the date of general public, okay, then the ROC can proceed to strike off. Provision for realization of the amount. The ROC before striking off will satisfy himself that the sufficient provisions have been made for realization of the money due. and for payment of discharge of all the liabilities and obligations of the company within reasonable time. So they will take necessary undertakings from the director, manager, etc. The assets of the company will be made available for payment of discharge of the liabilities even after the order of removing of the name from the register of company. So ये important है और common sense भी है कि obviously strike off ऐसे थोड़ी ऐसे strike off कर देंगे, उसके assets होंगे, तो assets का there has to be provision of realization, सामान बेचो पैसे realize करो, pay off the liability, so all that has to be done before the strike off. And notice of dissolution shall be in form STK 7. All of you all are answering as if it's a very baby chapter. Okay. Now coming to the next thing, strike off by filing the way of company. Can anyone tell which section is it? Which section is it when the company is striking off, making an application? Very, very good. It's section, कौन सा है section 248 subsection 2, read with rule number 4. ये देखिए, गौर से देखिए, ये वाला होगा रूल नंबर 4. बिकॉज इसके बाहर तो आ नहीं सकता. स्ट्राइकिंग ऑफ में या तो आरओसी उड़ाएगा या तो कंपनी एप्लीकेशन देगी, दोनों में से. तो 248 सबसेक्शन 1 एंड रूल 3 कोट करने ही वाले हो. तो यहां पे आरओ कंपनी दे रही है, तो देन 248 सबसेक्शन 2 एंड रूल 4 ये कोट करना ही है तुम्हें एग्जाम में. कोट, तो टेक अ ब्रेक, लिसन टू व्हाट आई एम सेइंग. You are definitely going to quote because यहाँ से ही question आएगा. 248 subsection 1 read with rule 3, 248 subsection 2 read with rule 4. ठीक है. And rule 4 of what पूरा लिखेंगे, show off properly करेंगे. Rule 248 subsection 2 read with rule 4 of the company's removal of the name from the company's register, from the register of company rules 2016. Properly we'll write. Now they have asked, they have always tried to act funny and they have tried to ask something chotu sa in between. So this is an exam question. This is an exam question. Okay, important. So listen to it by heart करके अभी छोड़ेंगे हम लोग. Type of the company which cannot be removed under section 248 subsection 1 and 2. So what cannot be struck off? Listed company cannot be struck off. Section 8 company cannot be struck off. Company which has charges pending cannot be struck off. Where the compounding application is pending cannot be struck off. Companies against whom any prosecution is pending cannot be struck off. Vanishing company. Vanishing company is where the listed company's promoters have vanished. For example, Vijay Mallya. है क्या विजय माल्या का कॉन्टैक्ट? इंडिया में किसी के पास में भी विजय माल्या का कॉन्टैक्ट है क्या कि वो वैनिश हो चुका है, डिसअपियर हो चुका है? सो सच नीरव मोदी इज देयर और व्हाट? सो आंसर इज ऑल दीज पीपल दे हैव वैनिश्ड. सो कंपनीज, लिस्टेड कंपनीज whose promoters have vanished are called as vanishing companies. So which has been delisted due to non-compliance. So companies which where an inspection का please section tell me the section number. एग्जाम में कोट करना ही है तुम्हें because ये repeated होता है. Okay, tell me the section number of inspection. Very very good. It is section number 206. Whatever I am telling you, book pen लेके chapter wise sections, rule numbers, form numbers लिखना है और एग्जाम में स्कोर करना है. full 25 out of 25 लाना है. Inspection is there. A company having public deposits outstanding, you can write the section for public deposits also, section 73 to 76A of the Companies Act. Then companies having where the notice under section 243 have been issued by the registrar. 243 is for merger and amalgamation of foreign companies, foreign company merger. Okay, so remember, if there is with respect to merger application there, it will be there. So you have these 10 points which cannot be. Companies, types of companies that cannot be removed from the strike, from way of striking off. So what are the names? 10 hai, 10. All 10 I want. All 10. Which are those? Listed company, vanishing company. Vanishing company is also a listed company whose promoters have vanished. सेक्शन 8 कंपनी, अरे भाई एनजीओ को उड़ा दोगे क्या? एनजीओ जो नॉन प्रॉफिट ऑर्गेनाइजेशन फॉर द वेलफेयर, जस्ट बिकॉज थोड़े टाइम से नहीं हो रहा है तो यू ट्राई इट ऑफ फॉरवर्ड? नो, चार्जेस आर पेंडिंग, भाई पैसा बाकी है, यहाँ पे भी केस पेंडिंग है कंपाउंडिंग का, यहाँ पे प्रोसिक्यूशन पेंडिंग है, हाउ वी कैन स्ट्राइक ऑफ? यहाँ पे डी लिस्टिंग जस्ट हुई, अभी अभी उसको तमाचा पड़ा है, अभी अभी उसको डी लिस्ट किया हुआ है, ऑलरेडी रो रही है कंपनी, उसको तुम अभी अभी लिस्ट करके डीलिस्ट किया है, उसको तुम मार दोगे? लेट इट बी नाउ, नॉन कंप्लायंस किया है, अभी थोड़ा सैड होके फिर वापस कंप्लायंस करना चालू कर देंगे. नेक्स्ट, इंस्पेक्शन इज गोइंग ऑन अंडर सेक्शन 206. पब्लिक डिपॉजिट्स आर आउटस्टैंडिंग and notices of merger is there pending before the court. Okay, so they cannot be delisted. All the 10 points I want you to remember and learn. ये एग्जाम में आता है, all 10 points you need to write. Next, a company through its directors can file an application for removal from this on the following grounds. अब ये भी हम लोग ने देखा था, same points है. When can the directors file? Okay, so all 4 points are the same, means so what, why are they giving the same points? I will not read, I will make you remember that what is this logic. Logic समझो, ये पैरा उड़ जाएगा. In all the cases where the ROC could have strike us off as it is, then the company realized कि यार better they do, we only go and surrender ourselves. So in all cases where striking off by ROC is justified, in such scenarios the directors can apply and ask the company to strike off. आप रेडी हो मारने के लिए, इससे पहले मैं खुद ही अप्लाई कर देता हूं. क्लियर? यस. So listen, on what grounds can the board of directors file for removal of the company? Obviously same points. 1 year of incorporation not commenced. Second is 2 preceding years, the operations have ceased to exist. Third, the memorandum and subscription money has not yet come. That section 10A, within 180 days from incorporation, that declaration has not come. Fourth wala, physical verification, we came to know that you are not carrying on business. So in all these points are there. ROC can strike off, but ROC must have not found you yet. You can only apply, the directors can proactively apply for removal of the name. Clear till here? Now next, situations in which a company cannot apply for striking off under section 248 subsection 2. This is also a past exam question. Okay, very very important. It's a past exam question, supremely important. Okay, and it comes in the exam. It is high possibility it comes in your exam. Okay, let's see क्या है ये. When a company cannot apply for strike off under section 248(2). So if it has changed its name, it has changed the registered office from one state to another, they have disposed of property immediately before the seizure of trade, okay, for the purpose of gain in normal course on carrying on business, has changed any of his business activity except for striking off purpose, you've done. Next, has made an application to the tribunal, for a scheme of M&A and is being wound up under the Insolvency Act or Bankruptcy Code or in the chapter 22, that's about winding up. So 6 situations where a company cannot apply. What is it? What are the 6 situations? First one, he has changed its name. Company has changed its name from A Limited to B Limited. So then we will not allow. अभी तो नाम बदला है, नए नाम से भी चलाओ, from the new name also run. So you cannot do. If you change the registered office from one place to another, now you want to strike off, not allowed. Third, you have disposed of certain value of the property immediately before stopping your business activities, okay, for gain in the for the purpose of disposal, for gain in the normal course of business of trading, otherwise carrying on business. So basically what are they saying here? If you disposed of your business or your rights immediately before shutting ceasing your business operations, you cannot come for striking off. Has engaged in any other business activity, you cannot do. Has made an application for M&A and has been wound up. So 6 points, all the 6 points I want you to tell. What are the 6 points? Confirmed it comes in the exam. Situations when you cannot apply. If you have changed your name, नाम बदल दिया तो नहीं कर सकते, जगह बदल दी नहीं कर सकते, सामान बेच दिया नहीं कर सकते, देन धंधा बदल दिया नहीं कर सकते, कॉम्प्रोमाइज मर्जर करने वाले थे नहीं कर सकते, वाइंडिंग अप का एप्लीकेशन कर रहे थे नहीं कर सकते थे. सो चेंज ऑफ नेम, प्लेस, सोल्ड प्रॉपर्टी, चेंज एक्टिविटी, M&A and winding up. So in all these cases, if you have done, you could not change. Now coming to the procedure for striking off of name by way of application to ROC. Very, very simple. Now they're just telling procedure. So what is the law? We have to just repeat it here. First, we know that one thing is there. Let me just tell you one point, that we require a special resolution. Procedure में I told you special resolution or no? So we will write that for special resolution, first there is a board meeting required. Pass the board resolution. Then while passing the board resolution, you have to file the forms. STK2, remember? STK 2, 3, 4. So STK, you will go directly. STK 2, 3, 4 you will write. And STK 6 procedure में लिखेंगे कि नहीं? And end में 7 भी लिख देंगे. So you will give all the sequence forms, okay? STK 2 is your 3, 4 be sorted hai. If special resolution you require MGT. 14 convene a general meeting. Then with that you will attach certain documents. With your STK2 you will attach certain documents. What documents you will attach? Firstly, a NOC from the authorities, the regulators, RBI, IRDA, Housing Finance, if it is applicable. Indemnity bond in STK3. Then a statement of accounts certified by a chartered accountant in STK8. STK8 bhi hai. That statement of accounts by a CA, that you can conduct the business. The statement should not be older than 30 days. So if I am telling the ROC that shut me off or shut down the company or kill the company, so ROC will want to know that what is the statement going on, what is the current state of affairs. So STK8 में CA देगा. Affidavit from the directors in STK4, a true copy of the resolution, statement regarding any pending litigation. All these form numbers are covered. STK7 has to be filed, okay, on dissolution. Then it should be signed by the authorized person. Now very, very, very important, STK form 2. Company secretary has to sign. A STK form 2, a certified CS or a CA or a CWA will have to certify the STK2 that you've done properly. Public notice, I've told you, STK6. So if you know the form numbers with the headings, you can very easily build your answer, okay? Intimate the regulatory authorities, all those, and get a NOC. Okay, then they will strike it off. Realization of the amount due, same point as before. Assets होंगे तो बेच के पैसे लेके we will pay off the liabilities. Notice for dissolution, and once it is dissolved, STK7 will be filed. Okay, and the same should be placed on the official website of the MCA website. Next, no objection certificate from the appropriate authority. So mark it as important. STK2 is there, so no objection certificate is required and shall be attached to this. NOC shall be required and it will be attached to the STK2 we saw above. So if it is a banking company or a NBFC, they will have to take a NOC from RBI. If it is a into the housing finance company, then we have a regulator, the National Housing Bank. They will have to take approval from them. Insurance company will take approval of IRDA. Then your CIS scheme is there. Then it will be SEBI. If there is an asset management company, you'll have to take approval. So these are all what? These are all what? In other words, I'll tell you they are sectorial regulators. Sectorial regulators का approval लेना पड़ेगा. Any other company which is regulated by any other law. Status of a struck off company. Tell me one thing. If a company has been struck off by ROC, does the liability also end? Answer is no, liability will never end. So, if a company stands dissolved under section 248, it shall, from the date mentioned in the notice of the resolution to cease to operate, and so it will first cease to operate. So notice of dissolution जो था STK 7, वो जो डेट होगा उस डेट से it will cease to exist, and the certificate of incorporation shall have deemed to have been cancelled. So that certificate of incorporation also is deemed to have been cancelled. And lastly, except and the liabilities, except for realizing of the liability. So liabilities can be realized. So this is also really bad. So three bad things can happen. What are those three bad things in status of a struck off company? Pehle, it will cease to operate from the date of in STK2. Certificate of incorporation will be deemed to have been cancelled. And third, only for discharging the liabilities, the provision will still continue to exist. Clear? Fraudulent application for removal of the name. Fraudulent application for removal of the name. If someone has made a fraud application for removal of the name, so what we will do? I made a fraud application. The main reason I wanted to strike off so that I could defraud the creditors. ये company मुझे बंद करानी थी ताकि creditors को कुछ पैसा ना मिले. Creditors को inform भी नहीं होगा. ROC को I fooled the ROC and then quickly shut down the company and I tried to run away. So what will be the effect if a fraudulent application has been given? You think ROC will be happy? ROC will be extremely unhappy and this all will happen. If it is found that an application has been made with the objective of evading the liabilities of the company, अगर पता चला कि एक application है, it has been made, this application has been made with the object, इसका main object था to evade the liability, to skip the liability, and with the intention to deceive the creditors को उल्लू बनाना था या defraud करना था किसी को. So in that case, every person, the director's liability will become jointly and severally liable. So the person in charge, who will become liable? So the persons in charge will be jointly and severally liable to pay for the losses and damages and will be punishable for fraud under section 447. So if I was a person in charge and I had given a fraudulent application, all the persons in charge, their liability will be joint and several. Joint and several का मतलब क्या होता है? If you and me were there, let's say, I don't need to explain, but still I'll tell you. If there is Mr. A and Mr. B and the liability is of 1 lakh, so jointly मतलब 50,000 इसकी liability है, 50,000 इसकी liability है. But if this guy ran away, so then the full 1 lakh can be recovered from him. So this is called as joint and several, means joint liability is also there, that in case if that guy runs away, your liability will be on you. You can later recover from the other person. So just explaining joint and several. For you have to remember all those persons who were in charge, their liability will be joint and several liability, and they will all be liable to pay for the damage that has been caused due to striking off, and you will also be liable for fraud under section 447. ये सब कोट करना है. फॉर्म नंबर्स चलिए ये तो कर ही लिया हम लोग ने. एक आठवां भी था, राइट, STK 8. प्लीज पुट इन द चैट बॉक्स what was STK 8 about. What was STK 8 about? What was STK 8 about? By auditors, statement of affairs by the auditors. Now coming to the next thing, restoration of name. This is also pretty easy and simple. Okay, very good, very good. So the restoration of name, अभी देखते क्या प्रोविजन है इसका restoration of name का. If ROC had given a notice to me under STK 1, but for some reason I was out of India, or I had changed my registered office, or I couldn't reply, and ROC considered that as no reply and struck off the company, so I will be aggrieved. मैं एकदम sad हो जाऊंगा, अरे मेरी कंपनी चलती फिरती कंपनी को तुमने उड़ा दिया. If you struck off my company which is functioning, so in such case we will apply for restoration of the name. कि भाई the name should be restored. Then, and this restoration can be done in court. We will have to give this application in NCLT, and NCLT we will tell, and this has to be done within 3 years. This restoration by aggrieved person will be done before the NCLT, that is the tribunal, within 3 years of the date of order passed by the ROC. And we will say restore the name वापस डाल दो. If tribunal found that the name was wrongly removed, the tribunal will order restoration of the name, and the effect of restoration will be as though the company was never struck off. एक बार कंपनी रिस्टोर कर दिया ना, इसका मतलब कि कंपनी अगर हम लोग मानेंगे कभी स्ट्रक ऑफ हुई नहीं थी, ठीक है, बिकॉज गलती ROC की थी. So pay attention, okay. Now the ROC can suo moto by issuing a notice strike off the name of the company, but it may happen that the name of the company may be struck off by the ROC even though the company was active, or due to just non-filing of reply. In such a case, the aggrieved person can file an application and appeal in NCLT. Very, very good. So appeal for restoration. Now pay attention to what I am saying. Any aggrieved person, कोई भी aggrieved person may file an appeal before the NCLT within 3 years of date of passing the order. If the tribunal is of the opinion that the removal that the ROC is not justified, then it may order an order for restoration of the name after giving an opportunity of being heard to the ROC and the company and all the persons concerned. सबको बोल देंगे कि भाई restore कर रहे नाम. Application. Now we are coming to this application for restoration by the name of the company. Now the ROC may, within 3 years from the date of passing the order, the ROC may, within 3 years from the date of passing the order dissolving the company under, can file an application before the tribunal before seeking the name of such company if it is satisfied that the name has been struck off inadvertently on the basis of incorrect information. So if the ROC is sad that I struck off the company, मुझे नहीं करना चाहिए था, गलती हो गई मुझसे, it was an inadvertent mistake, it was a unintentional mistake, it was an innocent mistake. So the ROC will apply within 3 years कि भाई मुझसे गलती हो गई है, I have made a mistake, restore the name. So वो अपने पाप धो रहा है. Okay, so what is this? The ROC may within 3 years from the date of passing the order file an application. So the ROC files the application here. So the ROC files an application before the tribunal for restoration of the name. Okay, if it was inadvertently done by him or it was done by incorrect information. ठीक है, तो ROC का टाइमलाइन कितना है? 3 years. Now we will see how much time has been given to specifically to these people. ये लोग को कितना टाइम मिला है? मेंबर्स, क्रेडिटर्स और वर्कमैन. These people, members, creditors and workmen का time limit अलग है for restoration of name. So if it is a member, creditor or workman, so they are more impacted, they get more time. So the application, very good, correctly put up 20 years. So the application to NCLT for restoration of the name by the company, member और क्रेडिटर और वर्कमैन, ये लोग 4 जन, 1 2 3 4, इनको कितना टाइम मिलता है? 20 years, 20 साल. The tribunal may on application by 1 2 3 4 aggrieved by the company's being name struck off before this 20 years from the date of publication in the notice, if it is satisfied that the name has been struck off, was carrying on business, or it is just the name that you want to restore, it may by order ask the ROC to restore the name. And the effect, now pay attention to this, effect of non-restoration, effect of restoration. ठीक है, छोटे छोटे लाइन्स है बट अच्छे लाइन्स है. सी दिस, व्हाट इज दिस थिंग, that the tribunal may pass an order giving an order for restoration. Okay, and the effect will be as if the name of the company had not been struck off from the register of company. So the effect of restoration will be as though the company was never struck off. Then comes striking off. We are almost on the end. We are done with section 248. You can be extremely happy. Now we are giving striking off of name of LLP. Just like we have companies, we also have limited liability partnership. The Ministry of Corporate Affairs have given the powers for striking off of LLPs to ROC only. तो ये भी कौन करेगा? ROC ही करेगा. So the LLP Act 2008, LLP Rules 2009. So LLP Act is of 2008 and rules are of 2009. So first we are getting the provisions in place. बाकी का सब सेम है. Provisions खाली याद रखने हैं, फिर कोट कर सकते हैं. So as I said, similar to how we have 248, here also we have section 75. So remember this, section number 75. I will ask you, you have to put it, okay? So what is the section number? Section 75. एक ही section है इसका, ठीक है, जो याद रखना है. Section 75 और Form 24. So for LLP, चलिए, for LLP, for limited liability partnership, which is covered under the Act 2008 and which is under the rules 2009. Okay, we will have to quote every single thing that I am teaching you. You have to quote the form, rule, section in the law, in the act, in the exam and come. मुझे ये मत बोलना कि तुमने कोट नहीं करा. I am teaching you because you have to go and write in your paper. Okay, so go and write. Everyone, whoever is listening to the video will write the section number. ये कभी नहीं बोलोगे तुम कि याद नहीं रहता, ये नहीं रहता. मैं याद करा रहा हूँ, जो मैं याद करा रहा हूँ वो तुम्हें लिखना है. Whatever I am making you learn, that you have to write. So take a book and pen and write it. Very clear instructions and order has been given. Okay, you have to. Now for LLP, it is section number 75. And which is the rule number? What is the form number? Form is 24. Okay, and this is the rule number is 37. So this is the section, this is the rule 37, right? Rule 37 of the LLP rules. Okay, and the form number is what? 24. So this is the provision. Rest very similar you will find to this part. Okay, now let's move ahead. Legal framework. तो भाई हमको क्या बता रहे हैं, हमें पता ही है फॉर्म नंबर 24 है. Now one thing is there, what are the conditions? So this is important. Okay, in case of an existing LLP, same conditions are there. One, ROC will strike off, one, you can only apply, same things. So in case the LLP which is not carrying on any business or operations for 1 or more year, it can make an application to the ROC with consent of all the partners for striking of its name. Okay, so this is the first part where in this, what are we seeing? That the LLP can apply for strike off to the ROC, for strike off to ROC. In the second part, just like we have for companies, the second part is here. Similarly, where the ROC has reasonable grounds to believe, which color today? Okay. Where the ROC has reasonable grounds to believe that a limited liability partnership is not carrying on business with the provision of the Act for a period of 2 years or more, then it may strike off the LLP by suo motu. Okay? So here ROC strikes off LLP, but the timelines are different, right? LLP can apply when it is not functioning for 1 year, but ROC can do when it is not functioning for 2 years. Yes or no? Can you see this? Because मेरे को पता है कि मेरे को नहीं करना है, तो जैसे खुद ही बोल रहा है तो इसको एलिजिबल कर देंगे to strike it off. See this, 1 year, and here we have ROC has reasonable grounds to believe that it is not functioning for 2 years. So ROC has to wait for 2 years before it can strike off. Procedure is exactly the same. You give a service or notice to the LLP, wait for a reply 30 days, listen to the representations, make a publication of notice. Fifth one, strike off the name of the company, provision for realization of the money due. So if you are striking off, there must be some assets, you will recover the money, pay off the liability, then you will strike off. And then seventh is notice of dissolution. So headings you can learn, headings you need to learn, and internal content you will write in this way. Section 75 read with rule number 37 of the rules are given here. Okay, so ROC will serve a notice, same points. Reply to the notice, so the partners will have to reply, they get 30 days time, same, 1 month's time, same points, procedure is the same. ROC will obviously use the same procedure, na? Consideration, so he will consider the representation, matlab he will listen to both the parties, he will give a publication in the notice in the newspapers for striking off, then he will strike off the name, provision for amount due and notice of dissolution is exactly the same. Yes, procedure same है, because ROC तो वही procedure follow करेगा ना, exact same procedure. Now strike off by way of filing by the LLP. Now LLP is filing, so what will be? So section 75 read with rule number 37, they are given. So procedure for striking off for LLP. Now remember that when ROC strikes off, it's easy. But whenever the company strikes off, they have to give affidavit, indemnity bond, the statement of affairs of the auditors, वो सब करना पड़ता है. Same इधर भी same है. पहले वो लोग एक मीटिंग कराएंगे. And I told you the form number also I told you to remember. Which form number? 24. ये रहा. Form number 24. Form 24. Okay. So the partners will take in form 24. They will strike it off. Consent of all the partners is to be obtained before filing. Annual filing 8, 11 also has to be given. Okay, 8 and 11 both have to be filed. Approval. So these are the LLP forms which are there. If you want to see what are the form numbers 8 and 11. So if we do the LLP chapter 8 and 11 क्या है? So what is form 8 and 11? So 8 is a statement of solvency, statement of accounts, and 11 is an annual return. So annual return and statement of accounts. So this is statement of accounts, the statement of affairs, and this is about annual return. Annual return. Both they have to file. You have to get approval of the authorities, just like we had seen. All the designated partners will be joint and severally be liable for all that they do. They have to give the following documents. What are the documents? That they don't have any liabilities, certificate of a chartered accountant, income tax return, affidavit, indemnity bond, everything is the same. Okay. Then that the limited liability partnership has no liabilities and indemnifying. So same thing in them, same points you can write. The LLP has not opened any bank account, okay, to transfer the money. The LLP has not filed any income tax return which is not carried on the business for its incorporation. So all these are certain supporting documents. You will publication, strike of the name, restoration of the amount due, notice of the dissolution. Liabilities of the partners continue after striking off, same point. Powers of the tribunal to wind up. So the tribunal have a power to wind up a LLP in the same way that we had seen for companies, they do a shutting down. Here also will do a shutting down. Restoration of name. Now I feel this can come in the exam. So this is important from exam point of view. Exam point of view. Okay. Now what is this? Restoration of the name. How we have, you can apply in LLP Act or rules. There is no similar relief for restoration of the name. What you can do, you can the limited liability. So there is no relief provided in the LLP Act or the rules for restoration of the name. Imagine that अगर strike off कर दिया ROC ने, so there is no provision only in LLP Act for restoration of the name. So then what you will do, this they can ask you a question. Listen to me. They can ask you in the question that in such case the LLP have a power to approach the jurisdictional high court to file a writ petition under Article 226. And that is it. We are done with the chapter. Clear? So now if we see the exam questions, what is the stated of fraudulent application for removal of the name? We saw. Then companies which cannot be removed through the procedure under section 248. So we've given all these cases, same points. Then the next question is, in case of application for removal, what are the attachments in STK2? STK2 I told you, NOC, indemnity bond, affidavit, statement of accounts, special resolution copy, Okay, and pending litigation if any. Now they have given you this question: ABC Limited was incorporated in this year due to recession. The could not commence business. They want to know the various grounds in which the promoters can close down the company for being non-operational. Whether your answer will change if they have changed the registered office from Delhi to Noida. So whenever they have changed the registered office from one state to another, they cannot do. And that is given in a section 248 we have given, 249 they have given, that if you shifted the office, then some of the officers of ROC carried out a physical verification and they found that there was no business operations carried out. So then what they did, they struck off the name. They wanted to remove. What is the question? Whether the ROC has the power to strike off. Okay. So these are the situations where ROC can remove the name suo moto. So he has the power because four conditions were there, right? Out of the fourth condition, the fourth point was if it was revealed that physical verification was done and they were not carrying on business. Now you need to tell me what is STK2, what is form number 24 and MSC4. MSC4 is for that dormant company. So this they have asked, very simple and easy. Then the ROC has filed the field. Now this was a past exam question. There was a case law, International Securities Printers Private Limited versus ROC. So just keep a note, just take a screenshot of this. If you all don't have, just go to the app and download these notes. So there was one case law in the module. This is the International Securities Printers Private Limited versus ROC. Take a screenshot of this. In this what they said now, that the procedure given is mandatory. अगर बिना प्रोसीजर फॉलो किए अगर आरओसी ने किसी को भी स्ट्राइक ऑफ किया तो वो इनवैलिड है. एनसीएलटी विल ऑर्डर रिस्टोरेशन. So in this case it was held that the ROC is under a statutory obligation to follow the procedure given under section 248 subsection 1. Notice, advertisement, notice to the regulators, public advertisement, all of that is mandatory. If that is not followed, then it would be struck off. Then if ROC did not follow the procedure and struck off, NCLT will order restoration of name. Then in this case they have given what happened here, what type of specific certificate are to be submitted by them. Along with this, types of companies which are required to submit a certificate, brief on the penalty of non-compliance. Is a non-housing finance company incorporated which had failed to commence the business and now proposes to make an application to ROC for removing of the name. So they are talking about section 248 subsection 2. So पूरा procedure लिखेंगे and then they will say that you have to take. Now also remember it is a home finance limited, तो regulator का भी नाम देना पड़ेगा. And NOC is required from the appropriate authority, that is your home finance corporation approval is needed. So it is possible that you might do a strike now. It wouldn't strike you that home finance company sectorial regulator approval is needed. Okay. Now then in December 2021 they've asked this, remove the name from restoration. The directors have approached you to seek your advice to whom and when they should file an appeal for restoration. A very simple restoration application. ROC may file an appeal within 3 years. Explain the situation in which a company cannot apply for striking off of the name. Change the name, change the state, the value was sold, then he has changed any other change the activity, merger, amalgamation and winding up. And that is it. We are done with this chapter. Every single thing we've covered in the exam, it will come from here. Only one thing is there about penalty. Okay, just point is there of penalty. Even learn that because in the exam they've asked the penalty amount also. So penalty amount was also asked. So right now I can't find, but if you find the penalties given, okay, for non-compliance here. So market is important. Okay, this is important. So if the application is made in violation of section 48, it shall be punishable with fine which may extend to 1 lakh rupees, and an application filed under section 248 subsection 2 shall be withdrawn, rejected. So just remember the fine is 1 lakh penalty, okay, for non-compliance. So that is it. We are done with chapter number 20 as well. Okay, so now we'll take a short break and we'll come back. So I'll just put the time and we'll be back. We'll just take a short break and we'll come back. Okay. So I'm done with chapter number 20 in complete detail. Now we'll just see the lesson number 21 after the break. I'll put the break when I'm coming back in some time. Okay. Am I audible to you all? Hi guys, I just need a confirmation from you all that I'm audible. Okay, so I will be starting with the part lesson 21, the most important chapter from here. Let me show you what is the exam weightage for this subject. Okay, so there is around confirmed, I feel 15 marks can be asked from this chapter alone. It's that big. Okay, so what I need you to do, it's a very big chapter. I have prepared a technique where you can finish this really fast and very easy. एक इतना simple technique बनाया है. I made such a simple technique that you will be able to understand what this is about completely. Okay, so let's begin with this. I want you to finish this particular topic with me. मेरे साथ में ही खत्म करो. Don't leave it for later. If I am there, you're sitting live, leave every single thing, whatever you're doing, and keep your module in front of you and finish it with me. Okay. First, I will give you a little bit of background about the CIRP concept. Okay. And then we will begin. Yep. Okay. So let's begin with the Insolvency Bankruptcy Code of India 2016, your lesson 21. Now, the Insolvency Bankruptcy Code is contained, the law relating to insolvency in India is contained in the IBC Code 2016. Now, all of you will take a book and pen and we will all quote certain things in our exam. Confirmed question will be from you. The Insolvency Bankruptcy Code has total of 5 parts. It has 5 parts. Out of this, being a company secretary, for us, part 2 is of most importance because it talks about insolvency of companies. Part 3 is about insolvency of individuals. Part 4 is about certain regulators. Part 5 is miscellaneous. This is preliminary. So can I say that? Yes, don't worry. I'll explain with proper examples for a person who is first time listening also will know. Okay. So now part 2 is what is important for us. Section 44 to section number 57. Okay, this is important. So whatever exam is coming in the exam, we will write it is part 2 of from section 4 to section number 77. Now let's understand how does it work and what are the provisions. Now first we'll go with the module and what questions they can come. Just a second. Yeah, sorry about that. There was just some glitch. Okay. Now, hi. So we'll be starting with your lesson number 21, CIRP regulation process. We will be covering every single topic from this thing, and I believe the questions, whatever is asked, will be from what I'm going to teach you now. So keep your books, modules, and book and pen ready and finish it with me. The very first thing they are talking about the difference between insolvency and bankruptcy. What is the difference between insolvency and bankruptcy? So directly I'll tell you, insolvency is a state, insolvency is a state, insolvency एक ऐसा state है, situation है, it is a situation where your liabilities are greater than your assets. Okay, when a situation when my liabilities are greater than the assets, it is possible that I will get out of insolvency. If insolvency continues to exist for long, it is possible that it can lead to bankruptcy. Bankruptcy का मतलब क्या है? Bankrupt is a order of court. It is a order of court saying that I am insolvent and after an entire process. So let's read. Normally this is used interchangeably. लोग इसको commonly use करते हैं. However, insolvency denotes one of the states whose assets are insufficient to pay the debts. So assets are less than the liabilities is called as insolvency. However, bankruptcy is a legal status. Bankruptcy is a legal status by an entity who cannot pay the debts to this. It is a process that begins through a petition of court. Okay, and it is a declaration by court. Insolvency is the inability to pay, whereas bankruptcy on the other hand is a formal declaration of insolvency by a court. Then insolvency is a state, whereas bankruptcy is the conclusion. तो insolvency एक किस्म का situation है. कभी कभार you might get broke, your liabilities might be more, so you are in a insolvency. But if the court determines, we will call it as bankruptcy. This can be an exam question, very important. If insolvency is not resolved, it can lead to bankruptcy. Clear till here? Is the first part clear? So this can be your question number 1 in examination. One question can come, difference between bankruptcy and insolvency. It has come in the past exam question also. Is this clear? I want a yes or a no. Then we start the law relating to insolvency and bankruptcy code in India is your IBC code 2016. Now if we go to see this, okay, here this is your code entirely. From a company secretary point of view, part 2 of the IBC 2016 is the most important because it talks about two things from which your questions in the examinations will come. One is CIRP and the other one is PIRP. Corporate Insolvency Resolution Process and Prepackaged Insolvency Resolution Process. So these are two things mentioned in your part 2 relating to companies. PIRP. What it is, we will see. Now what happened is, in India the insolvency process, due to the overburdening of courts में इतने matter रहते थे कि matter used to go up till average matter used to take 4.5 years. Matter used to go on and on. So what happened? The government said that internationally in all the other developed countries 2 साल में matter खत्म होता है, 2 से 3 साल में खत्म होता है, हम लोग का 4.55 years जाता है. This was a report by the World Bank. So then what happened? A committee was formed in India, which was the BRLC committee, the Bankruptcy Law Reforms Committee. So first thing, very important, they can ask you which was the committee that was formed which led to the introduction or formation or introduction of the Insolvency Bankruptcy Code of India. It is a BRLC committee which was under the Ministry of Finance. Okay, it got its assent on all this and it got its president's assent. Now the code consolidates all the existing framework with respect to IBC. Means India में वो time पे जो भी laws थे with respect to insolvency bankruptcy was consolidated. Okay, so we had certain laws such as Okay, just so we had cases such as so there were all these laws before this. Okay, before the IBC, I'm just giving you a background so you come to know. So there were all these laws before the IBC. There was a Sikh Industrial Companies Act and all these acts. Slowly, because of the introduction of IBC, this act was removed, this act was removed, for this it was removed, Companies Act 1956 was removed, Sikh Industrial Companies Act was removed. Okay, all these act was removed and we all consolidated into one, which was the IBC code 2016. Now one important case law which I wanted to quote. Okay, so this whatever they've given here, Sikh Industrial, Presidential Town, all of this is here. ये सब को repeal करके all of this we have a IBC code 2016. Clear till here? Now there were few cases given here that the innovative industries versus ICICI Bank. The case law was innovative industries versus ICICI Bank. This was the first case in IBC code. This was the first case of the IBC code. So इसलिए important है, they can ask you the innovative industries versus ICICI Bank. In this, what was held? इसमें क्या बोला था? That the IBC code is a complete code in itself. It's a complete law and it has overriding powers over all or any other insolvency law. मतलब अगर कुछ भी कहीं पे भी लिखा है तो IBC code will prevail. तो एक लॉ था महाराष्ट्र में, महाराष्ट्र रिलीफ ऑफ अंडरटेकिंग स्पेशल प्रोविजंस एक्ट. So tell me which one will prevail? IBC will prevail or any other law relating to insolvency, any other law? Which one will prevail with respect to insolvency? So they said that IBC code is more superior. So it was held that by the Supreme Court that the IBC code shall prevail over any law with relating to insolvency. तो मतलब ये मेन लॉ है इंसॉल्वेंसी रिलेटेड. क्लियर यहां तक? नेक्स्ट they spoke about even in the next case, Commissioner of Income Tax versus Monet ISPAT, the Supreme Court confirmed that insolvency law will override anything inconsistent in any other enactment. मतलब Supreme Court, even in the Commissioner of Income Tax versus Monet ISPAT and Energy Limited, it said that IBC will override anything else, is what it was given. Then come to section number 2. Section number 2 says that this code applies to what all cases? To whom all the code applies? So let's see. If I take you through, यहाँ पे insolvency के laws applies, the IBC code applies not only on individuals, on corporates given under chapter 2, on individuals given under part 3, on partnership firms given in the part 3. So it applies on all of them. So it applies on companies, it applies on LLPs, it applies on individuals, it applies on partnership firms, etc. So section number 2 is saying that this act applies to who all? Corporates, LLPs, firms and so your corporates, individuals and firms. So all these three के ऊपर ये apply होगा. So it applies on companies. So IBC code applies on companies / LLP. It also applies on firms / individuals. Till here it is clear. Whenever there is an insolvency of a company or a LLP, the matter will go in NCLT, National Company Law Tribunal. But if the insolvency is related to a firm or a individual which doesn't have separate legal existence, then the matter will go to Debt Recovery Tribunal, called as your adjudicating authority. So both of them are courts. This is a company court. This is a court specially made for recovery of debts due from individuals and firms. Then moving ahead quickly, They have given the salient features of the IBC code. Mark it as important. They can ask you. Okay. So the salient features of the Insolvency Bankruptcy Code 2016 is, firstly, they have given you certain bodies. The IBC code has introduced certain bodies like your IBBI, adjudicating authorities, IPs, IPAs, and information utilities. 5 things they have introduced. Now pay attention. I am going to cover, at least speak on all the topics. So even if you know, you can pull off a 5-mark answer. Okay, and something which is completely not there, you take a note and later you can study extra from it. Okay, because here I am doing with the amendments, latest one. Okay, so here if I talk about various people, okay, now pay attention to what I am going to tell you. The Insolvency Bankruptcy Code has many units, many uh, agencies in it. The first one is IBBI, Insolvency Bankruptcy Board of India. So this is the main regulator, of insolvency matters in India. Just like we have SEBI for securities law, for insurance companies we have IRDA, same way for insolvency matters we have IBBI. There, IBBI will handle information utilities, will oversee the functioning of insolvency agencies and insolvency professionals. Let's see who are they and what is the function of them. So first, the IBBI will accept registrations of IPAs, insolvency professional agencies. What are insolvency professional agencies? So these are a Section 8 company. These are a Section 8 company whose main job, this agency's job, is to register professionals, insolvency professionals. So 3 bodies have been registered till now. I will tell you. One is the ICAI IPA, the ICSI IPA, and the ICWA IPA. Means what? Your institute, ICSI, our institute, they have formed a Section 8 company and they've been registered as a insolvency professional agency as well. Okay, so their job is to conduct examinations and to regulate the professionals, to take disciplinary measures. Same what ICSI does for company secretaries, same way IPA does for insolvency professionals. And here there are certain examinations that will be conducted. Once the exam is conducted, you have to give those exams, and moment you've given that exam, you will be registered as a insolvency professional. Insolvency professional will do all the work which is given in your IBC code. Then there is something called as information utilities as well. Their main job is to collect and collate information with respect to daters. Okay, means what? Vijay Mallya ran away, Nirav Modi ran away, so many people take the money and ran away. If the creditors had the information of these daters, they wouldn't be at loss. So many banking companies wouldn't be at a loss if they had this information of the data. So this information utility job is to collect information on regular basis, record information so that there are no losses. So if I take you here, you can take a screenshot what it is. First, IBBI. What is the function of IBBI? IBBI, so it's a regulatory authority. They will register all of them. Adjudicating authorities is your NCLT and DRT. IPAs are the specialized body which will register and govern in insolvency professionals. Insolvency professionals are like you and me who give examinations, and if we clear the insolvency professional examination, we will be registered as a IP and we can do the work of IP. Information utilities job is an agency to collect, collate, disseminate information with respect to the data. मतलब वो लोग data के trace करेंगे उनको, ठीक है? Now, so this is what they've given. I've spoken in short about IBBI is the regulator, adjudicating authority. It has courts, NCLT and DRT. Insolvency professional agencies are your Section 8 companies, which job is to register and conduct examinations for IPs. Insolvency professionals are those who have given the examinations conducted by IPs. Information utilities are agencies that collect information and disseminate the information so that there is no loss to the creditors. Okay. Now, once they have given, so we will be studying this in detail, so you don't have to do this. This entire process they have given you. Now the tribunals they have given you. So the tribunals are something like this. Take a screenshot here. So if there is a insolvency, so I'll be covering everything. Okay. So whatever I do from there only it will come, because I want you all to score full. Insolvency of companies will be taken up in NCLT. If you go in appeal, it will go to NCLAT, and if you go in appeal, it can go to Supreme Court. If it is with insolvency of individuals or firms, you will go in appeal to DRT, and beyond that you will go to DRAT. So DRT and NCLT are the adjudicating authorities. Great. Now, in resolution process, there are two independent stages. Now coming to this part, okay, this point. You all tell me if there is a insolvency. Now I want you all to understand, in the Insolvency Bankruptcy Code 2016, whenever there is a insolvency, should the government and all of us work towards reviving the company, or we should work towards killing the company, liquidating the company? What should we do? Tell me, we should revive the company or we should liquidate? I want you all to put in the chat box what we should do. We should revive or liquidate or wind up the company. What we should do? I want you all to put in the chat box. अगर एक company insolvent हो रही है, तो उसको shouldn't we try to revive? Very, very good. So we should try to revive. So we will revive the company so that we protect employment. Okay, so that we protect business, and we try to put a turnaround strategies should be done. Turnaround strategy मतलब loss making को profit making करना है. So our very first part of the Insolvency Bankruptcy Code is to work towards revival. Revival का दूसरा word is rehabilitation. We will try to revive, rehabilitate, bring it back into profitability. But जरूरी है कि हर एक कंपनी को तुम revive कर सकते हो? Is it necessary that every single company will be revived? A sick company, if one is sick, you try to save it, right? But sometimes it is not necessarily possible, and in that case we will then go for liquidation. Clear till here? So the first step is to revive, but if we can't revive, then the most logical step is to shut down the company. Clear? In liquidation, you sell off all the assets. So first we will try to revive. The word that they have given is your corporate insolvency resolution process. We will try to resolve the problem. We will try to revive or solve the problem. If CIRP process fails, corporate insolvency को revive नहीं कर सके, if we couldn't revive the process, only then we will go for liquidation. Understood till here? That is what they have given. Let's see. There is always two stages. First, we will try to revive the business. Rescue and revival. We will try to revive the business. If the insolvency resolution fails, then we will decide to wind up or distribute the assets. Clear? So for revival, we have a concept called as CIRP, Corporate Insolvency Resolution, means revival process. Clear? Till here we are completed. Now we are going to see the structure of the code, which is very, very important. Now, this is your entire IBC code. First, we are not concerned really with anything else. We are concerned with chapter number 2. We are concerned with chapter number 2 and chapter number 3. The first stage we will try to revive. So revival is given in your corporate resolution revival process. Section 6 to section number 32. And for that we've also made our regulations, insolvency resolution process for corporate persons regulations 2016. If CIRP could not be done, then we will do liquidation of the company, and for that also we made a liquidation regulation process. Till here it is clear. Now a addition has been done. This is the amendment. Chapter 3A has been added. Chapter 3A has been added, which is talking about your pre-packaged insolvency resolution process, section 54A to 54P, and for that you have your pre-packaged resolution process regulations 2021. Clear? So whatever question is there, it will be from chapter number 2, chapter number 3 and chapter number 3A. Clear? So whatever is there, questions will be framed from chapter number 2, chapter number 3, chapter number 3A. We will quote along with these sections. Till here it is clear. Then they've also given one small little part about what is fast track insolvency process. What is the fast track फटाफट छोटे लोगों के insolvency? For that also they've given you regulations 2017. Then they've spoken about voluntary winding up, when the company itself passes a special resolution कि हमें बंद कर दो. That regulation is in 2017, and that's it. Okay, so this much is important. Now definitions are definitely you need to read. As and when I'm telling, I will explain. From here you can read what is a corporate applicant, what is a financial debt, what is a insolvency process cost. All the definitions you read at once, because 2 marks to 3 marks they ask in definitions only. So I will be directly explaining you the provisions. Now we start with a CIRP process. Now we start with the main provision which comes in your examination. Okay, so this is very, very important. Okay, so pay attention. I'll give you the full structure of CIRP. You will understand and you will find it very simple after that. Okay, so these are with the sections. Okay, and I want you to quote the sections also so that you get maximum marks. First, anything comes about CIRP, Corporate Insolvency Resolution Process, which 110% it will come. You will write it is contained in part 2, section 6 to section number 32. Okay, of the IBC code. Now let me tell you how it works. I'll tell you in short and I want you to draw this with me. Okay. The very first thing, there will be a default, right? Insolvency process. Let's see how it is. Okay. In short, we are calling it as corporate insolvency resolution process. I'll give you cut to cut. Okay. Which will give you the overview. You have to draw it with me just to understand. Firstly, there will be a default. Very first thing, that there will be a default in payment of loan. There will be a default. Moment there is a default, the person, there will be someone who will file a case. So on default, there will be 3 people involved. Okay, 3 people who can file the case. This is given in your section number 6. Persons who can file for CIRP process in court. First will be your financial creditor. Financial creditor is a person who has extended a financial debt. मतलब लोन दिया है उसने. बैंक, अगर तुमने बैंक का पैसा, एक कंपनी ने बैंक का पैसा डिफॉल्ट किया, so the company will use and file a case in NCLT. Second is a operational debt creditor. Operational creditor is a person who has extended a operational debt. एक operational debt दिया है. For example, your supplier of goods or service could be employees also. Clear? So default हुआ होगा, company must have defaulted in payment of some money. So either you could default for financial debt, loan पे default किया है. For example, we are giving your example loan, your employees salary. And third, who can file on default is the creditor himself, the debtor himself. The debtor can file the case. They will all go to NCLT. Now they will go to National Company Law Tribunal. The financial creditor will go directly to NCLT. Corporate debtor can directly go on default, they can go. But when we have operational creditors, they cannot directly go. They can go only after giving notice of default. मतलब उनको कंपनी को देना पड़ेगा, आपने हमारा पैसा नहीं दिया, मैंने आपको गुड सप्लाई किए थे, you didn't pay me. So a demand notice will go. If the demand notice is not given, after that, after 10 days only they can go. So it is something like this. I'll take you through this. Okay. So the company defaults in payment. Financial creditor can directly go to NCLT. Corporate debtor can directly itself. Sometimes the debtor itself, like Reliance. We had this Reliance Communication directly went to NCLT. We couldn't pay the money, they went. An operational creditor, if I have extended a goods or services to the company and company not paying, then I have to give a 10-day notice to them. और डिमांड नोटिस के बाद ही मैं NCLT के पास जा सकता हूँ. So this can go directly on default, whereas this guy has to give a demand notice. Once we go to NCLT, एक बार any of these 3 people will go to NCLT. So then NCLT within 14 days they can choose to either admit the application or reject the application. NCLT will say, yaar utha lo matter, let us go into this, or they will say no, we will not go. Once NCLT accepts the application, 4 things will happen. Moment NCLT has accepted the application, four things will happen. A CIRP process will commence, and within 330 days the matter should come to an end. So the maximum time period for completion for this entire process in the revival process should happen within 330 days. ठीक है? So first moment NCLT ने pick up कर लिया, it will tell कि timeline will start, timer will start, 330 days solve it. A moratorium period will be declared. Moratorium period will be declared is a stay order. NCLT will say matter has come to me. Now no case can be filed, no sale of asset can be done, no litigation can be filed. It's something like a stay. Everybody stop. Time please. हम लोग इसको revive करने की कोशिश करेंगे. We'll try to revive it. Next is public announcement. NCLT will make a public announcement that this company is now, we have picked up the matter and now the CIRP process will begin where we will try to revive the company. And then they will appoint a IRP, Insolvency Interim Resolution Professional. अब इस बंदे का काम आता है IRP का. एक प्रोफेशनल को NCLT ने उठा लिया, बट उसके बाद में we will take it forward. So then we bring it to a interim resolution professional. Moment an interim resolution professional is there, he will immediately take possession of the assets. Imagine I am appointed by the court for this company to revive them. So immediately I will take control of all the assets and the control management. I will ask people किस-किसका पैसा बाकी है, किसका default है. I'll verify the claims and I will constitute a committee of creditors. So IRP will then constitute a committee of creditors. It's all those people whose money is pending. Then this committee of creditors will now decide by a 66% vote who they want, whether they want that IRP only to continue as a main resolution professional or they want to appoint a new RP. Whoever it is, once the RP is selected, then what he will do, he will get an information memorandum. He'll get an information memorandum about full company status. It will invite resolution applicant. It will invite people कि किस को company को revive करना है, आ जाओ. And it will try to prepare a revival plan. कि company क्यों डूबी, क्यों loss में गई, how we can revive it. So the insolvency professional is an expert in reviving sick companies and making it back into profitability. तो कुछ plan बनाएंगे हम लोग. एक बार ये plan होगा, plan will be submitted to the creditors. Creditors 66% votes have to approve. If they approve it, then it will go to NCLT. Then this resolution plan has to be successfully implemented within 330 days. If it does, then the company survives. If not, then the liquidation process will be there, and then we start with the second part, which is the liquidation process. Till here it is clear. So this is what I want to know. I want you to write. This is the CIRP process in short. CIRP process summary. Okay, now pay attention. First, there is a default. जैसे default हुआ, application होगा कोर्ट में. There will be an application. Application can be given by a financial creditor, by a operational creditor. Operational creditor has to give a demand notice of 10 days. Only then it can file in NCLT. Or by the corporate debtor himself. Debtor ही बोल रहा है कि यार मुझे कुछ revival करो यार, मैं बीमार हो गया हूँ. I am sick, please revive me. Once the application is given, okay, then matter is given in NCLT. Application is given in NCLT. Then NCLT will appoint a IRP, Insolvency Resolution Professional. Then the IRP will constitute a committee of creditors. Committee of creditors. No. So RP is a resolution professional. Resolution professional or resolution plan, depending in which context it's used. So पहले default होगा, तभी गाड़ी मतलब तभी कुछ ना कुछ इंसॉल्वेंसी की बात होगी. Then application कोई ना कोई करेगा NCLT के अंदर. NCLT will appoint a IRP. IRP is an insolvency interim resolution professional. Why interim? Because he will prepare the committee of creditors by taking everyone's claim, etc. Then committee of creditors. Then the committee of creditors say, resolution professional बनेगा. who will then find a plan, a revival plan, resolution plan or a revival plan, which has to be approved by the committee of creditors 66% and also by NCLT. If approved, then well and good. Otherwise, if the plan is successful, otherwise you'll go for liquidation. Take a screenshot of this. This is the process in short. So first, default, then application is in NCLT. NCLT appoints a IRP, then IRP appoints a committee of creditors. Committee of creditors then appoints a resolution professional. Resolution professional then tries to revive the company. If not revived, then he'll go for liquidation. The section numbers are here. Now this is the section number. Okay, so this is the section numbers to remember. Section number 6, who can apply? All these three people can apply. Financial creditor will go in section 7. 8, the operational creditor will have to first give a demand notice in section number 8. After 10 days of demand notice only, then he can file a case. Then the corporate debtor will file. All this time limit, moment NCLT has picked up the matter, in 330 days, the entire CIRP process should get over. Moment NCLT has picked up the matter, in section number 13 they say it will declare a moratorium period. A moratorium period is stop everybody, no more jhagda, no more fights. I will now let the resolution professional make a revival plan. Public announcement and appointment of IRP. IRP will then make the committee of creditors and so on. Okay, so now let's go from the module. Initiation of the CIRP process, section 7. Financial creditor can file a case and initiate the IRP process. Initiate the CIRP process. He will have to submit the following documents with him. Keep the proof of default and all of that, the name of the resolution. So they will all recommend who they want as a resolution professional. The adjudicating authority, that is the court, will pick up the matter in 14 days. My application is given, so in 14 days they will say whether they want to pick up or no. Where the adjudicating authority is satisfied, that NCLT is satisfied that default has occurred. Okay, or default has not occurred. If default is occurred, they will admit the application. If default is not occurred, they will reject the application. Simple. Moment NCLT has picked up the matter, the CIRP process shall commence from the date of admission. मतलब उस दिन से CIRP process will begin. So क्या होगा उससे? टाइमर चालू हो जाएगा. 330 दिन में वहां से सॉल्व होगा मैटर, because from commencement 330 days revive, otherwise liquidate. Now we are talking of initiation of CIRP process. So earlier we saw who's initiating the process? Financial creditor under section number 7. Now we are talking of initiation of CIRP process by operational creditor, section number 9. Now he can file only in section number 9 if he has issued a demand notice under section number 8, and it's a 10 days demand notice. So the corporate debtor, so here operational debtor may deliver a demand notice of the unpaid operational debt, okay, involved. So the operational creditor may, on occurrence of the default, deliver a demand notice. तो जैसे default होगा ना, यहाँ पे see, moment there is a default, then you have to deliver a demand notice. Operational creditor, he cannot just go in court. He will have to give a demand notice. The corporate debtor will get 10 days to repay, but if 10 days are over, after the expiry of 10 days, 10 दिन में पैसा नहीं आया operational creditor का, then case he can file. Then he will file a case in NCLT. Clear till here? Now coming to the corporate debtor himself filing. So it is section 7, 8, 9, 10. All these sections we have done, all of which may say ही question आएगा, you need to quote. So initiation by corporate debtor under section number 10. Corporate debtor itself is sick, is saying please revive me, कोई plan बनाते हैं. So on default, the corporate debtor will only file with all the details of books of account, who he wants the resolution professional to be, and a special resolution. Company है ना, तो company will pass a special resolution. Clear? Now we have done section number 6. It says who all can initiate a case. Section number 7, section number 8 and 9 are connected, and 10. Clear? Now coming to the suspension of CIRP. So what happened in COVID times? Everybody was defaulting because business ही नहीं हो रहा था. So then what happened? The government said for a period of 1 year, no matter will go up in court. So section 10 was inserted in 2020 through an ordinance, emergency law they introduced, and said that no application for CIRP can be filed for any default up to 1 year. तो 1 year का they said कि अभी मत, कोविड में तो सभी लोग डिफॉल्ट करें. अभी इसका रेलेवेंस नहीं है बिकॉज वो उन्हीं 1 year का था, एनसीएलटी में जो केस नहीं फाइल हो सकते थे. नाउ कमिंग टू द अदर इंपॉर्टेंट, टाइम लिमिट फॉर कंप्लीशन इज 330 days. 330 days में सीआईआरपी प्रोसेस खत्म हो जाएगा. उसका ब्रेकडाउन भी क्या है, 180 days दिया है, फिर और एक्सटेंशन से 90 days का एक्सटेंशन मिल सकता है, फिर और एक्सटेंशन तुमको मिल सकता है 60 days का. So initially the CIRP process shall be over within a period of 180 days. However, the NCLT can extend it for a period of 90 days. Okay, that too if the creditors have agreed. But not exceeding 90 days. Your 90 days is given here. And then total they are saying 330 days के अंदर से beyond खत्म हो ही जाना चाहिए. नहीं हुआ तो wind up, liquidation. Clear? Then comes withdrawal of application. If anyone has filed a case, they also have a right to withdraw. So the corporate data allows the corporate data another chance to make good the default even after the case has been admitted. So the adjudicating authority may allow withdrawal of the application admitted on any application date with the approval of 90% of the committee of creditors. So if he has made an application, we tell him mat karo yaar, give him some time so he can withdraw his application. Coming to moratorium, which I feel it can come in the exam. It has not yet come, but it can come in the exam because it's a very important, interesting concept. एक बार NCLT ने matter उठा लिया, once NCLT has picked up the matter, then stop. Whatever is doing, stop. No cases can be filed, no litigation can be done, no fighting, stop. Resolution plan चल रहा है, there is a revival plan going on, surgery चल रही है कंपनी के ऊपर, रुक जाओ. So moratorium period is like a stay order. Stay order. That stop, stay put. Adjudicating authority passes a declaration of moratorium period prohibiting all or any of the following: institution of any of the suits, transferring any of the matters or the assets, any kind of recovery or enforcement of security interest, recovery of any property, etc. So all of these things have been stopped. However, supply of essential goods shall not be terminated. जो normal day to day business वो चलते रहेगा. Okay. Now पब्लिक अनाउंसमेंट विल बी डन कि भाई ये कंपनी को हम लोग ने रिवाइवल में ले लिया है. सो पब्लिक अनाउंसमेंट, ऑल द डिटेल्स विल बी पब्लिश. इंटरिम रेजोल्यूशन प्रोफेशनल, अगेन वेरी इंपॉर्टेंट एग्जाम क्वेश्चन. ओके, दे विल आस्क दैट व्हाट इज द फंक्शन ऑफ आईआरपी. तो वेरी सिंपल, आईआरपी इज अपॉइंटेड बाय द एनसीएलटी. आईआरपी विल टेक ओवर द मैनेजमेंट, डे टू डे अफेयर्स. Okay, and they will try to get the committee of creditors. Here also they'll verify, make a list किस किस का पैसा बाकी है, shall constitute a committee of creditors. Then resolution professional, once IRP is there, he will constitute a committee of creditors. Committee of creditors will then give it to the RP. So what is it? IRP is appointed. IRP will create a committee of creditors. Creditors will appoint a resolution professional who will then make a plan. Now resolution professional, again the committee of creditors selects a resolution professional to revive the company. This has to be approved by the committee of creditors. Committee of creditors is a committee of financial creditors. सब financial creditors उसमें होते हैं, and they pass, any votes are passed by 66% votes. they will appoint a RP, resolution professional. Then comes the plan. Now, what's a plan? A plan is a revival plan to rehabilitate the company, bring it back into profitability, to revive itself from insolvency. There can be multiple resolution plans, multiple ways to revive, either merge, either sell the assets, either change the management, either take an extra loan, either for certain kind of restructuring, etc. So all that is a resolution plan. They will get a fresh chance to revive itself. There can be multiple proposals on how you can revive. Sometimes we can say that we will try to get a new investor on board. Then comes revival nahi ho paya. For some reason we couldn't revive within 330 days, or nobody, committee of creditors will not agree. So then we will go for liquidation. So only if CIRP fails, we will go for liquidation. So liquidation, we all know, is selling of the assets and recovering the money, paying off the dues. Jitna bacha baant do, jo nahi hai, then company will dissolve and wind up. So then now we start with winding up. Then while winding up, kisko kitna paisa milega, the hierarchy of payments, all of that will start. Okay. So here they are saying that this is also important. They can ask you what can trigger liquidation process. So let me take you through the process. Okay. Now we are going to the liquidation process. Here, chapter number 3. Okay. So first we try IRP process. If that doesn't work, then we go for liquidation. CIRP nahi chala to liquidation. In liquidation there are few important parts. Let's see. सबसे पहले होगा, who will do the liquidation process? When it will be initiated. So take a screenshot of this. Section number 33 says liquidation process will be initiated when there is no resolution plan. कोई plan ही नहीं बन पाया. Second, the resolution plan has been rejected. Third, committee of creditors themselves resolved to put it into liquidation. And fourth, the corporate debtor violates some of the plan. On passing of the order, the directors will lose their job. They will not have any power क्योंकि अभी company बंद करने का बात ही आ रही है. Or bar on all proceedings will be there. Liquidation steps, you have a liquidator appointed. Liquidator will be appointed. That liquidator will call for the claims. किसका पैसा बाकी है. Then he will create a asset memorandum. What all assets are there? He will see what all liquidation assets are there. Liquidation assets are कौन से assets है उनके पास to sell. Okay, some of the assets you can sell, some of the assets you cannot sell. So that way is there. अगर किसी ने कुछ गिरवी रखा है अपने पास तो वो तो नहीं बेच सकते. तो they've given you what all you can sell and not sell. Then you will sell, get the money and then distribute as per the waterfall arrangement. Waterfall arrangement is important and can come in the exam as well. We'll see what all it is there. Okay. So any other points? They can also ask you what is the duty of the liquidator. Very, very simple. He will get the claim, get the money, sell the assets, find out whose liability is there, pay off, get the money, close the accounts. Okay, so let's start. Where the adjudicating authority, before the insolvency process or the maximum period or this does not receive a resolution plan. So you did not receive a resolution plan, or it rejects the resolution plan, or any time the committee of creditors approve that the company should be liquidated. Okay, so in such cases it will trigger, section 33 is important, it will trigger a resolution plan, or when the corporate debtor has contravened any of the provisions, we will liquidate. On contravention, it shall pass a liquidation order. In the liquidation order, all the directors will lose their job, no legal suits can be filed. Okay, and the order shall be deemed to give notice of discharge. Discharge means they will lose power of the officers. So all this they have given. Okay, so this all is there. Section 33 is important, where it rejects the plan, or the committee of creditors have passed a resolution to dissolve, or the corporate debtor has prejudicially affected the application. Rejects the plan here if it is not completed within the time limit. So it is before the expiry. If the adjudicating does not receive a resolution plan. So here section 33 is important. It can come in the exam. Okay. So write it down. One is कभी होगा प्लान ही नहीं मिला, रेजोल्यूशन प्लान ही नहीं मिला, या मिला बट हमने रिजेक्ट कर दिया, या फिर कमिटी ऑफ क्रेडिटर्स ने पास कर दिया. No, I've covered everything in Dormant Company and strike off. Whatever I've done is with the latest amendment. Then corporate debtors have done something, where the resolution plan approved by the adjudicating authority is contravened by the corporate debtor. So in such cases, the adjudicating authority will pass the liquidation order. Important, note it down. Next, liquidator. Who is a liquidator? So then government has a panel of official liquidators. From that they can appoint and liquidate. So it's a professional appointed as a liquidator. Liquidation estate. Liquidation estate means what? All those properties which are under the liquidation, जिसको भी बेचेंगे. So section 66 lists out the items which can be included and excluded from the liquidation estate. Then comes distribution of the assets, will be as per the waterfall arrangement, which will be in the last part of the chapter, and dissolution of the corporate debtor. After all the assets have been realized, liquidation estates have been sold, फिर बाद में distribute करने के बाद में बंद कर देंगे हम लोग कंपनी को. Okay, that dissolution of the corporate debtor. Now coming to pre-packaged insolvency resolution process. Okay, this has been added in the amendment, and it is important. Okay, very important. According to me, confirmed 110% a question will be framed from the pre-packaged insolvency resolution process. Okay, confirmed it will come. So let's understand in short what it is. Pre-packaged insolvency resolution process. So I have made notes for it. These notes also I will put it in the app in the free section. In case if you don't get, just download the app. This will be there. Okay. So let's see. Let's start with this pre-packaged. Yeah. So this is in the new. It might not be there in some people's module, but this is there in the amendment sheet. See this. This I am taking from the amendment sheet. ये मैं सीधा amendment sheet से ही पढ़ा रहा हूँ. Where is it? Wait. Got it? So this I am covering the amendment. This is from the 2022 amendment sheet that we are doing. Yeah. In this, okay, lesson 21. Era. So your pre-packaged insolvency resolution process. Okay. Okay. So just give me 2 minutes of water break and we'll start with this process. Okay. Okay, so am I audible to you all? Just put in the chat box if I'm audible. Am I audible to you all? Just put in the chat box. I'll be starting with this PIRP process. A confirmed question to come in the exam. Going to confirm come in the exam, just waiting for your approval. Okay, great. So let's start. Now the pre-packaged insolvency resolution process. It is for micro, small and medium enterprises. This PIRP process is only for SME, MSME. So for large companies like Reliance, PIRP will not apply. They will have to go for CIRP. Okay. So let's understand the entire process that we did for all companies. We had CIRP, but the government made specially something called as pre-packaged insolvency resolution process. This is applicable. It is applicable only for MSME. Okay, not large organizations. Now let's understand the logic of this. So what happened due to COVID? Many businesses, the small, medium enterprises were hit, and they were the backbone of the economy. They directly got hit. So what the government said, and you imagine how much of defaults would have happened in the COVID time. So what the government said, like we need to do something to revive and protect and make a very nice, easy technique solution to this default that has been done by the small sector. So the president promulgated, passed the ordinance to 2021. Okay, in that they said that pre-pack. I'll tell you everything. Pre-pack is a restructuring plan agreed by the debtor and its creditors prior to the insolvency filing, that has been sanctioned by the court on expedited basis. So fast basis, I will tell you, section 54 A to P, talks about the read with your pre-packaged insolvency regulations 2021, lays down the provisions of PIRP. So important, note it down. Section 54A to section 54P lays down the provisions for PIRP. Now what does it say? Okay. So I'll tell you what is the provision. Very simple and very easy process also. Okay. So let's see, I'll show you the process directly. Okay. So I'll tell you what happens. It's a pre-packaged insolvency resolution process. Okay. So when I say pre-packaged means what? Before going to NCLT, before you reach up to NCLT, before you reach to NCLT, before you reach to them, the debtor and the creditor agree to a resolution plan. So there is an agreement between them. They agree to a base plan. A base plan is यार चलो एक काम करते, एक प्लान बनाते जो हम लोग दोनों agree करते हैं, and then they approach NCLT. So what happens? The process can be much faster because there is a prior agreement between the debtor and the creditor. Now this base plan is made prior to going to NCLT. That is why this resolution plan is already pre-packaged, already pre-decided by the debtor and the creditor. So it is agreed by the debtor, corporate debtor, and the corporate creditor. Now this base plan is prepared by the corporate debtor. So he prepares it. He also says who will be the resolution process. He will be in control of the business. The corporate debtor will be in control of business. And he will say, I'll tell you how it works. So the corporate debtor will tell, listen, I run the business, I know how I can revive. So I will appoint this professional, ये अपने को अच्छे से help करेगा, he will help me revive. This is the plan, what I am suggesting. Then next I will say, he will give a time limit on how does he plan to revive the company. So everything, and he will only be in control of the company. So these are all the prerequisites. Then we go to NCLT. NCLT will say, oh very nice, both of them का consent हो गया. Consent नहीं, then go in normal long CIRP process. ये उससे भी short है. दोनों का agreement हो गया है इसके लिए. There is an agreement already. That is why it is going to be short. Once the agreement is come, then already you have told who will be the resolution professional. Resolution is professional is there. He will make a resolution plan, and then that will be followed. The entire benefit. Now let's see the entire benefit advantages of PIRP process. Firstly, CIRP is long, is cumbersome. Okay. Here this is a simple procedure. पहले से दोनों agree करके sanction लेके complete कर लेते हैं. It's an informal understanding. So one prior requirement of this is of PIRP is both have to first agree. The pre-pack resolution plan allows the debtor and the creditor to work on informal plans and then submit to the adjudicating authority for approval. So it is flexible in its initial stages only. मतलब पहले से ही agreement हो चुका है, we know कि झगड़े नहीं होने वाले. It is all agreed upon priorly only. The management continues with the corporate debtor. Normally in CIRP, the resolution professional and the creditors really decide. Here what happens, the corporate debtor is only saying, I am a small guy, I am a small and medium enterprise, let me run my business, give me some time, this is how I plan to revive. They will both be there. Then they will start with the base resolution plan. A base resolution plan is prepared by the corporate debtor and agreed by the committee of creditors. Then what is the PIRP process? First, the corporate debtor passes a special resolution approving the base plan. It is agreed by the 66% of the corporate creditors. Who prepares this? The corporate debtor only prepares the base resolution plan. He only states who will be the resolution professional, and he makes a draft information memorandum. To NCLT, he will give the information of the company's current affairs, etc. Okay. Now, after the order of A, the resolution plan should be submitted within 90 days and the entire process should be completed within 120 days. So the best part about PIRP is it gets over in a short time within 120 days. The plan should be given, the ultimate plan has to be given within 90 days to the court. Time limit to complete the PIRP process, this is how it is important. It is 120 days from the commencement. So 120 days में pick up होके खत्म हो जाएगा. Now let's see and compare with CIRP. How is PIRP different? So in CIRP, it is available only to corporate debtor. Here it is available to any corporate debtor, right? Means anyone who is big or small can apply in CIRP. But pre-package is made only for the MSME sector. Only for the MSME sector. Only they can offer this pre-planned pocket. Now minimum default in your CIRP for the matter to be taken in NCLT. NCLT में अगर इतने का default होगा तो ही CIRP में process चालू होगा, that is 1 crore. If there is a default of 1 CR only, then the CIRP process can begin. For starting a PIRP process by the MSME, default of minimum 10 lakhs is needed. So 10 lakhs 1 crores. In CIRP there is no preliminary work. पहले से थोड़ी चालू होता है, application file होता है उसके बाद से होता है. In pre-package year, what happens? Already preliminary work is done of the base plan. The most important is the base resolution plan is already prepared before filing in the court. Okay. Then comes the time limit is 330 days. This time limit is 120 days. Normally, and one more important thing is here we saw is there is no IRP involved in PIRP. Directly resolution professional is appointed. Here we have a IRP, then IRP makes the committee of creditors, and then the committee of creditors appoints a RP. Here it is direct RP. And another important thing is the control. The control of the company in CIRP is there with the resolution professional. Here it will be with the corporate data. Okay. This one. Yep. That is it. So this was about PIRP. So PIRP, if I have to make the PIRP process, then what happens? This is NCLT. Before the NCLT case, before you go to NCLT, there will be the base resolution plan which has already been approved by corporate debtor and the corporate committee of creditors by 66% vote already. So this is the pre-packed, it's pre-decided. Then once the base plan is there, it will go to NCLT. NCLT will say that give us the finalization in 90 days and the entire thing will get over in 120 days in total. Okay, this will be there. Then the entire control is with the corporate data. So this is a much more friendly technique and that is why it is introduced. Section 54A to section 54P. So we are done with the pre-packed part also. So this is about the MSME, it is critical, etc. Then the provisions governing PIRP, the section 54A to 54P. Then we have the PIRP resolution process, eligibility, who can apply, it is only the micro, small and medium enterprise. Okay. And default amount is 10 lakh rupees. In CIRP, the default amount is 1 crore. Who can opt for this? Proposal of the name for resolution professional is decided by the corporate data. So corporate data only says who will it will be. Everything is done by the corporate data because we believe that he only knows how to run the business. Approval of the name, but he will appoint, it has to be approved by the committee of creditors. The majority of the directors have to give a declaration that it will be completed, the application will be initiated in 90 days, the entire thing will be completed in 120 days. It is not initiated to defraud anybody, and special resolution will be passed by the corporate data approving the plan, and then the committee of creditors also approved by 66% votes. And then the order will be passed to admit or no. Then the commencement is there. From the commencement within 120 days, the entire process should get over. Plan should be approved and given within 90 days. The entire implementation should be completed within 120 days. Same way, moratorium period will be announced. Moratorium period is during that time no case can be done, no removal can be done, no action can be taken. Then same point, the claim will be done, the management will be completely in the affairs of the corporate data. Okay, so that is it with respect to the PIRP process. Clear till here? So we are done with this part also, PIRP process. So this is very, very important. Do it well. PIRP is for MSME. They can only opt for this. And when they opt before going to NCLT, that's why it's called as pre-packed, because it is priorly, plan is already packed, already pre-decided by the corporate debtor and this खाली implementation execution का 120 दिन मिलता है. Clear till here? Is this absolutely clear? Okay, so this is the amendment sheet actually, which is there. So I will send it on the ICSI amendment sheet. You must be having. Okay, you can get it also. Otherwise, be in the WhatsApp or the groups, Telegram groups. I will give. And another important amendment is. So we have finished the amendment for this, which only talks about PIRP. Confirmed it will come. Now just the other one is about initial licenses and this thing where they are giving the definition of micro, small and medium. Okay, so then they have given what is the review, the MSME के लिए apply होगा, but who is MSME? So MSME के लिए limits are being given. Micro enterprise means where the investment in plant and machinery is not exceeding 1 crore and the turnover is not exceeding 5 crores. Okay, so micro, you have the turnover and you have the investment in plant and machinery. Okay, so these are the revised limits. Okay, so turnover is 1 crore. No, this is 1 crore and turnover is 5 crores. So you can make this thing. Okay, so here you have the investment in plant and machinery and then you have the turnover. So turnover is 5 crores. This is 1 crore. Small enterprise means the investment in plant and machinery. Small enterprise is the investment does not exceed 10 crores and does not exceed 50 crores. And medium enterprise is where the investment in plant and machinery does not exceed 50 crores and turnover exceeding 250 crores. So this is your limit for small, micro, small and medium enterprise, MSME new limits. So take a note of this limits. Okay, now moving forward to fast track insolvency resolution process. Okay, so this is very important. It can come in your exam. Now tell me, big matters which are extremely big and high end matters, can you do a fast track resolution for that? A fast track settlement can you do for matters which are really big? उसका फटाफट settlement कर सकते हो. High value cases, can you do a fast track case or you will do only for small companies? Put in the chat box. Fast track, fatafat, big matters can be put fast track or small matters will be put. So central government has made that a application for fast track insolvency process may be made only in case of following debtors. Only in case of following debtors. So a small company, a startup company and a unlisted companies whose total assets is not exceeding 1 crore. तो अगर 1 करोड़ के ऊपर नहीं है तो उसका फास्ट ट्रैक में सेटलमेंट कर सकते हो. वेरी गुड. स्मॉल कंपनीज ओनली. So this is the eligibility who can opt for fast track. Okay, fast track. Then fast track means in how much time will it end? So the time limit for completion of fast track procedures, it shall be completed within 90 days from the date of insolvency completion. Okay, within 90 days it will be settled. May extend the time if 75% of them have agreed, but may by order extend the time beyond 90 days but not exceeding 45 days. So completion is 90 days plus extension can be given of 45 days. Any extension of fast track insolvency process under this section shall not be granted more than once. Okay, तो एक ही बार मिलेगा. Very, very good. So 90 and 45 days. Manner of initiating fast track insolvency this. So how will you initiate? Show the proof of default. Okay. With the information available with the information utility which has the information. Okay, this is it. Now coming to voluntary liquidation. Voluntary liquidation, important exam question. Okay, this is a voluntary liquidation. So what is the points? Let's see. So these are all the points. Procedure for voluntary liquidation. All this is given. ये module है. You must be having in the module. Okay. So this is the. They can ask you a question, 5-mark question on voluntary liquidation. Now I'll give you a summary notes. Okay, for this you can take a screenshot. See here. Now I will teach from here. You have to write down the provisions. Okay. Voluntary liquidation. First, section 59 talks about voluntary liquidation. So write down the section there. Section 59 talks about voluntary liquidation. First, so voluntary liquidation, no default. If I want to do a voluntary liquidation, I shouldn't be in any default. Conditions are declaration should be given by the directors that they are solvent and they are not doing voluntary liquidation for defrauding anyone. These are the supporting documents. दो पिछले 2 साल के audited financial statements and a valuation report. Then you have to pass within 4 weeks of declaration. You have to give 4 weeks of declaration that you are solvent and not for default. Then you will pass a resolution, company resolution. Normally it will be a special resolution, but if the tenure is given or the event is given, then in ordinary resolution you will end it. Company will notify the ROC and IBBI. Okay, so declaration is done that we are solvent. Then you will pass a resolution. Then you will give the creditors consent and inform the ROC, and then NCLT will sanction the voluntary liquidation. You will appoint a liquidator. He will dissolve the assets. He will sell off the assets. Will pass an order for dissolution. The liquidator will look at all the assets, look at the proof of claim, verify, will sell off the assets, distribute as per the particular. The public announcement will be done, distribution of assets, and a dissolution report. So waterfall arrangement. So let's start. The insolvency process, section 59, okay, deals with the voluntary liquidation. Section 59 deals with voluntary liquidation. Procedure is given here. First, there will be a declaration from the directors that they are solvent and that it is not done to defraud anyone. They will have to give it the audited financial statements. Then you will pass a special resolution, or if the timeline is given, then an ordinary resolution. Then you will have to notify the ROC. Then a public announcement will be done. A preliminary report has to be prepared with respect to the company's current status. Get the submission of claims. Iska kitna paisa baki hai, get that. Open a bank account to put the money, and the amount, it will be in voluntary liquidation here. Sale of the assets, distribute as per the waterfall arrangement, and give the final report to NCLT. And then NCLT will pass the dissolution order. Waterfall arrangement is basically in which order it will be given. Money, assets have been sold, money is realized. But if the equity shareholder gets up early and comes in the meeting, will he get the money first or secured creditors will get? So then they have given you this hierarchy. You have to learn this. It is important. Okay, it can be an exam question. Who all it will be given to first सबसे पहले इंसॉल्वेंसी कॉस्ट के लिए पैसा जाएगा, देन द वर्कमैन ड्यूज, जो लेबरर्स है वो लोग पैसे लेंगे, देन सिक्योर्ड क्रेडिटर्स, देन जो दूसरे एम्प्लॉइज है उनको मिलेगा, देन द अनसिक्योर्ड क्रेडिटर्स, देन between the following the governments, central governments, then any other debts. So they have given you this. So this is the waterfall arrangement. Then after giving to the debts, then to preference shares and then to equity. So this is important. It's called as a waterfall arrangement. It will be given, it is given under section number 53. Section 53. And that is it. From here they will repeat everything about resolution process, etc. Dissolution. So and then in the end you get a dissolution order. Now all this is repeated. Okay, I don't believe it can come. We have to do the headings ऊपर से. It's done. All of this is completed. Okay, declaration process को वो लोग ने short में वापस repeat किया. Then coming to winding up. Very important. They can ask a question on winding up. So winding up is a process of bringing an end to the life of the company, where the assets are sold, money is realized, and the whoever's money are left will be paid off. Now in winding up is a process to the, now this is also exam question, very important, very important. Winding up is the first stage. Dissolution is when the company is shut down, it comes to an end. Winding up में क्या होता है, resolution पास होता है, assets sell होते हैं, money realize होता है, then liabilities को pay करते हैं. Once everything is done, then the liquidator will go in court and say that everything is done, and then he passes a order. That will be gone to the ROC. The ROC will strike off the name of the company and we will say it is dissolved. So dissolution is by court. Winding up is by the liquidator. Winding up comes first. This is the last stage. During winding up, company is still in existence. Whereas in dissolution, company ceases to exist. Okay? Then this is in winding up, one is called as compulsory winding up. Compulsory winding up is given in your section number 271. Many times they have asked in the exam. So one is if the company itself writes to ROC that you shut it, to NCLT that you shut it down. Second is if the company's existence is going to affect the sovereignty, integrity of India, it will be shut down. Then if it is being conducted, affairs of the company are being conducted in a fraudulent manner. If they've conducted a default for a period of 5 consecutive years. So if the company has made a default, okay. So if the company has made a default with the registrar for filing financial statements or this for 5 consecutive years, then it can be compulsory wound up, and if the tribunal is the opinion, it is just and equitable. So this is the most important 5 points you have to learn. Then this has come twice in the exam. Okay, this has come many times in your examination. So this is a exam question. Okay, it has come 2 times. That the winding up, a company's winding up rules 2020. So companies winding up rules 2020. In this, what they have said, that this is with a view to systematize the procedures. So it is a summary procedure for liquidation. Important highlights. I'll tell you what exam questions also they ask. That it allows the following companies to wind up their business by making an application to central government without approaching NCLT. So normally winding up is done to NCLT. NCLT takes time. So here you can go to, so it is done through CG and not NCLT. Companies who have accepting deposits up to 25 lakhs, or companies who have a loan up to 50 lakhs, or who have a turnover up to this, or who have paid up capital up to 1 CR, the above companies are allowed to approach the central government for summary liquidation only if they have a book value up to assets up to 1 CR. Okay, and this will be done in a fast track manner. Okay, thus the company winding up rules has reduced the burden of winding up by NCLT by shifting the power to central government, which has helped shortening the winding up timelines drastically. So this is important, and we are done with this chapter. Okay, so that is it. We are done with full part C. We are done with full part C. Out of 25 marks, you have to score 20 marks. Do everything perfectly. I have given you the past exam questions also 2-3 times, that only comes. Okay, so do that. You can download the question paper from the app. I put it up in the study material. Okay, so now we will start with the part B after the break. Now, let's see. Okay, so that is it. We'll take a break now. Ye part B. So we will see chapter number 13, how to handle it, 18 marks, and chapter number 17, how to handle it, is 15 marks. Rest all are chodu chapters which can easily be done. Okay, and one is IPR. So we'll try to cover these chapters and see. Okay, so we will see you all after the break. You all can finish your part B. You can finish your other stuff. We'll take a break and we'll return back around 7 o'clock now. 8 p.m. we start part B. Hi guys, am I audible to you all? I just need you all to put in the chat box if I'm audible. Okay, so we will start. We are starting with the labor law part. We are starting with the labor laws. Loud and clear, right? Okay. This is licenses. Labor law is chapter number 17, right? Which is chapter number 17. Okay. Okay, great. And I have the module in front of me. You all have to keep your module with you, okay, for labor law. Okay. Okay. So good to go. Can we start? I just require a thumbs up from your side that we can start. I will be starting and finishing it off the labor laws topic. Okay. Before we start, we'll just look at the exam questions. So when we are revising, we cover the exam questions. Okay. So what we'll do first, normally I do the chapter and then I do the exam questions. I will do in this chapter first. We'll just go through the exam questions first. Okay, just to see overview what all is there. Now this question is from the Right of Persons with Disability Act 2016. Explain the duties of educational institutions. Okay, very simple. We could have built it. Second, for disabled persons, what facilities should be there in the educational institution. So while doing the chapter, we will revise it properly. Okay, now which is this topic related to? Industrial Dispute Act. With this is with respect to strike. Okay, now strike topic we'll be seeing again. This is Industrial Dispute Act. Next, you are the company secretary. We are seeing all the exam questions. You are the company secretary. The board of directors has told you to prepare a checklist of the specific laws to be complied in the human health sector. Please prepare a checklist to be submitted to the board. Okay, for the human health sector, we have all these acts made. Okay, drugs control, mental health, etc. Then in June 2021, exam question of this This is with respect to they seek your guidance with respect to registration of trade union, forms to be submitted, minimum required, disqualification, cancellation of trade union. Okay. So this question was asked. Then we have is engaged in the business of 20 or more out of 11 draw a monthly salary of 25,000 each. 9 employees draw a monthly salary of less than 20. ठीक है, so this is with respect to ESI Act, Employee State Insurance Act. Then they have asked a question on this contract labor act. Then they have asked questions on internal complaints committee under the POSH Act. And what about this? Define the internal complaint committee. Then comes to December 2021 questions. Ram is working in a factory employing 30 people. Salary is this much. He has worked for 60 days. In the light of that, in the payment of bonus act. So we'll have to see what is the payment of bonus act provisions. Okay, great. Okay. So these are the past exam questions. Let's quickly start and finish. We've seen what all questions come in the exam, and let's start. Now before I start, just a small little disclaimer. I have made a book on the labor laws, so I will also refer to that book, okay, from the book that I have made. What you can do, if you like certain lines, sentences, you can take a screenshot, immediately write it, finish it with me. Okay? Chalo. Let's start. We're starting with the compliances and labor laws. Compliances under the various labor laws. The first one is your Factories Act 1948. Factories Act 1948. Now remember, in your exam, we know that there will be a theory question on labor law. No matter which labor law act comes, you can write few common points. That this is a labor welfare legislation. This is a labor welfare legislation. Always you can write. Second, you can always write that it is coming under the Ministry of Employment, Labor and Employment. Okay, so let's start with the Factories Act. First, any act comes, you will write the object and the scope of the act. What is the object of the act? कोई भी labor law का main purpose होगा, main crux of the act. So we will write what is there. The objective of the Factories Act, it is a labor welfare legislation. With me, whichever extra points are there, please write it down. I want you to finish studying with me. So till the very end, you will sit and finish it off with me. Okay. The main object of the Factories Act is to give adequate safety, health and welfare to its workers employed in the factory. If they ask you a Factories Act, you will write the object of the act always, because you have to write as it is. Small answers are there. Object of the act has to be there. So object of Factories Act is to provide adequate safety, health and welfare. Three things: safety, health and welfare to the workers. Clear? It also gives provisions for employment of women, young children, annual leaves, etc. Now then you will write that this act is administered by the Ministry of Labor and Employment. ये भी common होगा, labor law है तो Ministry of Labor and Employment ही लगेगा. So common, but you will sound very smart when you start your answer with the object of the act. Name of the act, object of the act, ministry governing. So the Ministry of Labor and Employment. Now let's see what all they have given. Correspondingly we will finish. Factories Act. Okay. Now they've said the state government may make rules with respect to all these things, whichever they've given. Okay. Okay. Now notice of occupier. So what I will do is, first I will tell you all the highlights of Factories Act. Abhi exam mein it's not necessary you have to write these lines only. If you have better lines from the act which I have made, you can write from there. Okay. So now let's see. Factory is a place where there is manufacturing process going on. Let's see what all is there first. Notice of occupier. Then general duties of occupier. Okay, what are the general duties of occupier with respect to health, welfare and safety of all workers? This is important. Now, who is an occupier? Occupier is a person who is in control of any unit. He is occupying the control over the factory. So, he is the occupier. What all will be his duties? His duty is to ensure that there is proper health, safety and welfare of all its workers while working in the factory. Simple. Again, they have defined who is adult. This, let's see which we can pull. Okay, now it will start. General duties of occupier. First, it is a duty of the occupier to provide health, welfare and safety to all its workers. Second, his duty shall include, okay, providing and maintenance of proper plant and systems of work in the factory, and that they are safe and without risk to life. Understand, if I am making Factories Act, I will say that I want welfare, health and safety of the workers. So safety will come of safety of many equipments. We will require proper toilets, we will require proper sanitation, we will require proper humidity, we will require proper per square feet space for the person. So we will see what all is coming. Okay, the provisions ensure that there is a proper, okay, we will provide that there is a proper maintenance of plant and machinery in the factory. Then arrangement for ensuring safety and absence of risk to the health. So there has to be arrangement in the factory for ensuring safety and absence of risk. So again, we will ensure that there is absence of risk to health. Next, the provisions of such information, instruction, training, instruction and supervision should be ensured for the health and safety of all the workers. So again, we have to provide information, instruction, training and supervision to ensure that proper everyone gets health and safety. Next, the maintenance of all at all workplaces, maintenance a condition that is safe and without any risk. So maintain of conditions which are safe and without any risk. And lastly, working environment which is safe without any risk. So now you have a working environment safe without any risk. So again, factory, object of the act, ministry, then you can start directly with the duties of the act, duties of the occupier. Occupier is those who are occupying the main control. Now coming to the main provision. So this is the main provisions of Factory Act. Okay, this is the main provisions. The measures to be taken for health, safety and welfare. ये words तो लिख ही देना है, object of the act, so we will repeat. Now, health के related क्या करना है for the health? So let's see. I have jotted down few points from my book. You can highlight it from your book. Okay. Now, first is health. If I want to maintain good health, I have to ensure that there is proper cleanliness. For cleanliness, we will see that now just see the points, okay, and just we have to build a 5-mark answer. That's it. Factory Act का आएगा, object लिखेंगे, basics लिखेंगे, and then we just have to build the answer. Cleanliness. So cleanliness means what? You have to keep the place clean, free from any nuisance. You have to ensure that all the accumulated dirt on the floor is removed and sweeping is done regularly. See, we are talking of people who are working in factories. So sweeping, then basic factory में क्या क्या होना चाहिए? Once in every week, the floor should be cleaned by washing with the disinfectant. Just think that in your house, what all they do? Simple, disinfectant. Then the exterior, the internal walls and the roof are kept clean. Whitewashing should be done once in every 14 months. It should be painted regularly. Painted once in 5 years. All the doors should be painted. Okay, and the dates on which the processes are to be carried out shall be entered in the register. So in the register, we'll have to maintain what all is being done. So let's see. Cleanliness mein, all the dirt and the refuse on the floor, staircases, passages shall be removed daily. तो रोज झाड़ू पता करने का, उसको एकदम हाई लेवल में बताया है. Second, once a week floor should be thoroughly cleaned. Next, effective method of drainage shall be employed for removing the water to the extent possible, which would come out due to certain manufacturing processes. Next, to ensure that the interior walls and the roof are kept clean, there is whitewashing once in 14 months. There is proper, it is being painted, okay, once in 6 months, and all the doors, windows are kept painted and varnished Okay, at least once in a period of 5 years, and the dates on which you're going to do the processes is to be maintained in the register. Till here it is clear. Simple. So just remember these points. In case they ask, we can write. This is for cleanliness. झाड़ू पोछा properly करने का, water clean करने का, dates में बता देने के register में, it has to be whitewashed. The doors have to be painted, and another word for painted is varnished. Right? Sound a little more intelligent. Okay. Then it is saying disposal of waste effluents. So whatever is a industrial waste, factory waste should be properly disposed of, and a proper treatment should be done. Treatment of waste and effluents. Next, ventilation should be there. Ventilation, adequate ventilation. Temperature should be there, which is reasonable for health and to ensure that it prevents any kind of health hazard. And a chief inspector should inspect the factory and adopt methods to reduce the excessive high temperature. Sometimes it gets very hot when some people so it gets very hot due to the processes, certain kind of processes. इन सब में CS का क्या लिखना है, लिंक है. Very good. So what happens is you could be employed in a company which has a factory. Okay, so I could be working in Parle, and there is a Parle factory, and there could be the person who is responsible is the occupier. He has to report. There will be inspection continuously. Inspection. There can be raids. There can be fines. There can be stop work notice. There can be closure. So a CS has to know all the labor laws and ensure that it is followed in his company. Dust and fumes. So I'm going to go a little faster. You can just read it. Dust and fumes. Certain manufacturing processes like chemical, textile, jute. Okay, there is dust and fumes. So we have to ensure that there is a proper ventilation there. It is injurious to health to employ such kind of manufacturing processes. Artificial humidification, decrowding should be there. So let's see if all that is given. Yes, so ventilation should be there. We should get ventilation for fresh air. Temperature should be reasonable so that we feel a little comfortable. Dust and fumes. What is the point with dust and fumes? Effective measures should be there to prevent inhalation of dust and fumes. Otherwise, you take a deep breath and you're having some poisonous gas. So that shouldn't happen. Artificial humidification. Now again, what is about artificial humidification? Okay, that humidity means moisture in the air. In industries like cotton industries, textile, cigarettes, the high degree of humidity is there, which for this purpose humidity in the air is artificially increased. This increase or decrease in humidity adversely affects the health of the workers. Okay, so again, humidity means moisture in the air. In industries like cotton and all of that, the degree of humidity is high. It can adversely affect the workers. Okay, so therefore the state government prescribes certain standards for humidification and how to maintain a proper temperature which is good for humans to work. Then comes decrowding. Decrowding means what? In one place, if nowadays obviously in COVID everybody likes to stay at a different place, but imagine if you are there and I make two people sit next to you really close, really close, and tell you to study, would you be able to study? Answer is no. That's overcrowding. So overcrowding, how are they defined it? Overcrowding in a workroom not only affects the worker in efficient discharge of their duties but their health also. Next, section 16 is enacted with a view to provide sufficient airspace to the workers. Again, sides में ठीक है, but what if आगे ही दो जन को रख दूं मैं? So then where will you breathe? If he is exhaling, you are inhaling. So imagine what kind of atmosphere is that. Okay. So that is overcrowding. Understand, these are all to be written. I'm not talking anything. I'm giving of law. I'm reading the law. It sounds a little funny, but obviously we have to do it. In exam once and for all, whatever I tell you now, बस सीधा एग्जाम उसके बाद रिमेम्बर कर लेने का, आंख बंद करके कि सर ने क्या बोला था. Then next, apart from the general prohibition, lays down the minimum working space that each worker 14 cubic meters space is required in every workroom. So 14 cubic meters की जगह चाहिए. 14.2 इतना तो जगह थोड़ा फैल के बैठना है, काम करना है, तो थोड़ा it should be there. Shouldn't be that I'm stretching and I touch 2-3 people. So I don't want that. 14.2 cubic meters space should be there. Then let's see what is else given. Then lighting. Tell me one thing. Would you like to work in the night? Would you like to work in a dark environment? Imagine it's very dingy and suddenly someone plays music and someone plays some flickering light. Instead of working, people will be dancing. So in lighting, let's see what provisions they have given कि बराबर light होनी चाहिए. So provides that making proper provisions, every factory must maintain sufficient lighting, natural lighting, artificial lighting in every part of the factory. Now we have focused on natural lighting, sunlight. It shouldn't be like how we have in TikTok and all that. They have this ring light and sitting and you're working. That kind of light we can't use. We require natural sunlight windows. Okay. So lighting में not for that social media जिसमें eyes में ring light दिखती है, वैसा वाला ring light नहीं चलेगा. Okay. Now coming to drinking water also. Now drinking water should be there or it shouldn't be there. If we won't drink water, then what we'll have? So again, they've given you certain points. Pay attention. That every factory shall make effective arrangements for sufficient supply of drinking water for all the workers. Next, water should be wholesome, free from impurities. Okay, water should be supplied in suitable points, convenient for all the workers. So it should be there at all the different points. Okay. Then no such point shall be no such point should be issued within 6 meters of any washing place urinals. So if you go sometimes in all these cinema halls, what they do, so that you buy bottled water, the drinking water they'll keep next to the toilet. So no point shall be done within 6 meters of a urinal. Drinking water shouldn't be there because you don't know what you'll end up drinking. Then this is an important point to be noted. In case where there are 250 or more workers employed, okay, then you should have proper arrangements for drinking water. In case, what is this? Where there are 250 and more people employed. Okay, when there are more than 250 persons employed, okay, following additional measures, all latrines and urinals shall be prescribed sanitary type. They should have proper tiling. They should be washed clean at least once in 7 days. Okay, so all this is there. Now just understand, if whatever is there in your module, there would be Factories Act, right? Factories Act law doesn't change. So whatever you have to build an answer, whatever I'm reading might sound funny, might sound weird, that sir is talking about urine, whatever it is there in the book. Okay. Again, they have come, I was just talking and they have said latrines and urinals. Okay. So proper urinals should be there. Every factory shall make suitable arrangements for latrines and urinals. These points are subject to the provisions laid down below. Every factory shall have this as per the prescribed standards. This should be convenient, accessible to all the workers during the working hours. Separate arrangement should be made for male and female. Okay. All these places should have suitable lighting and ventilation. No latrine or urinal shall communicate with any workroom unless there is a provision for open space or ventilation. Okay. It should be kept clean. A sweeper should be kept to keep everything clean. Then comes spittoon. Spittoon is the basin, where you brush your teeth and you spit. That spittoon. Every factory shall have sufficient provisions for proper spittoons. These are maintained in a clean and hygienic conditions. Now coming to safety. So whatever it is, just pay attention, make notes and finish it off. Now coming to safety. In safety, what they've given you. Now safety, they are saying that how the employer will be, the workmen will be safe. So there has to be proper fencing, because if there is a proper, let's say a roller or a fan, okay, and turbine, and it is not fenced enough, and someone it just gets a small push and you move towards that fan, it's risky. So there has to be proper fencing. So here they have put it here in this way: fencing of machinery in use which is in motion is obligatory. This is mandatory. Such type of machinery, every moving part of the prime mover, the water wheel, electric generator which is dangerous shall be properly fenced. Then safety near the anything, employment of young persons on dangerous machines. So no young person, tell me the most dangerous person, the most dangerous machine. All the adults say, "Arey, we will not take it, let that child go, he will handle it. Let that young person go, he will handle that risky part." So they are saying, no, that is not okay. No young person shall be required or allowed to work at any machine unless it has been fully instructed that the dangers with respect to the machine have been properly maintained. Then let's see which other points are there. Protection of eyes. Protection of eyes. So again, the state government shall make rules required for providing effective screens or suitable goggles for protection of a person's employed in immediate vicinity wherever there is a manufacturing process going on. Okay, because there could be a risk of injury to the eyes if it is exposed to certain excessive lighting. So there has to be proper goggles provided, protection of eyes. Then let's see what else point we can add. Safety officers. Safety officers. So wherever in a factory there are 1,000 or more workers ordinarily employed, where the manufacturing process involves a risk of bodily injury, then we should have a safety worker. So whenever there is 1,000 or more workmen, we need to have a proper safety worker. Then comes welfare conditions. Now welfare is welfare. So I told you the entire Factories Act is talking about health, safety and welfare of workmen, employment of young persons subject to certain conditions, annual leaves. That's it. The entire law gets over. So only this much we have to remember and write. 5-mark answer is there. You should be able to build certain points. Okay. Now welfare. So whatever I am reading from your book, you quickly keep marking. That 5-mark answer you can build. Object तो सबका लिखना ही है. तो तुम्हारा ऑलरेडी थोड़ा बन चुका है आंसर. मूविंग अहेड टू वेलफेयर. नाउ वेलफेयर में क्या करेंगे हम लोग? फॉर वेलफेयर वी विल गिव देम वॉशिंग फैसिलिटीज, वी विल गिव देम फर्स्ट एड फैसिलिटीज, ओके, ड्राइंग देयर क्लोथ्स etc. Main is the first aid, canteens, these are important, restrooms. Now first aid appliances, at least one first aid box for every 150 workers should be there. So first aid box for every 150 workers. We have to have at least one safety first aid box, and in that safety first aid box nothing else should be stored. In our house, how we have in some dairy milk box, you will find all those stitching, all those things, you will find some other thing put. That shouldn't happen. Okay, then it should be accessible and reachable during all times. We are talking about first aid box. Where there are more than 500 persons, you need to have an ambulance room as well. Okay, so talking about where there are more than 500 ordinary persons working, we need to have an ambulance room also provided. Now coming to crutches. Crutches is play area for really young or small children, for really young children, okay, or I could say infants or children. Now what happens, wherever there are women, they can have their children who are very young. For them we need to have crutches. Now what is this? Crutches in a factory where there are more than 30 women workers. Okay, so if I come to crutches, in a factory where there are more than 30 women working, ordinarily employed, they should provide and maintain for children under the age of 6 years for women. Okay, so crutches of 6 years तक बच्चे लोग की खेलने की जगह होनी चाहिए. Okay, there should be adequate accommodation in such rooms, and they should be sufficiently lighted, and women should be trained in the case of children. Infants should be in case of such room, in charge of such rooms. Women trained or in children and infants will be in charge of this room. For some reason they have said they have not allowed men to take care of these children and infants, because we know men will keep harassing these children. Now welfare workers, wherever in a factory you have 500 or more workers ordinarily employed, the occupier, the person in control of the factory, shall have a welfare worker. So now we are done with the Factories Act. Okay, now very important, your Factories Act is over. Okay, is over. From your side also it should be over. We will write the object of the act, we will write the Ministry of Labor and Employment, we will write the main provision. Always just write down whatever you are getting which you can build. You can just keep writing, okay, the headings and finish it off. So after I teach, you should not have anything left to study for this chapter. Second, we are doing the Minimum Wages Act. Okay, Minimum Wages Act. We have to set the minimum wages in India also कि कम से कम इतना तो पगार मिलेगा. Very good act. It is very much welcome act. Now minimum wages has to be set by the government, but imagine there are so many different fields, so many different kinds of work. So first what the government does, they fix the minimum wage for different kinds of categories of scope of work. This minimum wage could be time restricted, for if it is a time bound, so then they will say minimum itna to per hour bharna hai. Okay. Second, it could be piecemeal, that for one unit itna milega. Overtime work, all that timings will be fixed. So let's go to the Minimum Wages Act, and you keep whatever sentence you like from my book, take a screenshot. Minimum wages, Minimum Wages Act. Okay, so I tried that actually, Pratik. It's very difficult to again and again it's coming. I've blocked that thing, but it's happening. Can't help it. Okay, now ignore it, let it be, ignore it. We are professionals, we can do that. Okay, Now coming to Minimum Wages Act. First, now everybody stop whatever you're doing and listen to what I'm saying. I want to show you the presentation of the answer. I want to show you the presentation of answer. The presentation of answer. Okay. So actually y'all block it. I keep blocking again and again. That thing keeps coming up. So y'all can please block it. Okay. Thank you so much. It's fine. I find it a little difficult to teach and keep blocking again and again. It keeps coming up. Okay. So that's a spam message that keeps coming. Now again, stop. So stop whatever I'm doing and listen to the Minimum Wages Act. How to present the answer where you sound intelligent when you're not. मतलब you have to sound a little more smarter than what you are, right? कभी नहीं आया तो provision नहीं आया. So what you have to do, any act that they ask, कोई भी act पूछेंगे, you will write the introduction and the object of the act. So how we will start? Minimum Wages Act, the main objective of this act is to fix the minimum wages. Why do we fix? So that there is no exploitation of the laborers. Okay, and the government will take steps to prescribe the minimum wages. Okay. Next, if we go to see what is the point they're given, fixation of minimum wage. So now we go to the fixation of minimum wage. Okay, now we'll go to the fixation of minimum wage. So this is the fixation of minimum wage. This is a past exam question also. Minimum wage कैसे fix करेंगे? Tell me one thing. Can you randomly say 2000 रुपए or you randomly get up and say 5000? No. It will be in a very systematic manner where government can either have two things. Okay, pay attention. What they can do, government can have a committee. Either they will have a dedicated committee to identify which all areas are there and what should be the minimum wage for that field, or a notification where the government can directly notify that this is the minimum wage. Okay, so that is how they can fix the minimum wage. Now, minimum wage can be fixed on the basis of time, can be fixed on the basis of piece work. For example, भाई 2000 रुपए घंटे का मिलेगा और 3000 रुपए पर पीस मिलेगा, or guaranteed time rate. Now I don't want to go into the details of what is guaranteed time rate, but just remember, when the piece rate is not sufficient, then they put a guaranteed time rate. You work how much ever you want for this time bound, but minimum base time तो इतना मिलेगा ही तुमको. ठीक है? So this is the guaranteed time rate. It's going to be fixed on piece, time and guaranteed time rate and overtime rate. So we'll fix all this. Now obviously every employment is different, so it will be fixed for different employments, different classes of work, for different kinds of people. If it is adult, if it is adolescent, if it is children, if it is apprentice, and different locality. Okay, if you go to see that the CS, any field also, in every state the rate is different. So let's see fixation. So if the government wants, the appropriate government. Now why do you say appropriate government? Because the labor laws come under the concurrent list. Central government can also make the law and the state government can also make the law. Okay. Yeah. Now fix the minimum rate of wage. Review at interval levels. So fixing of the rate, the government can fix the minimum rate and keep reviewing at different rates. Then if it is not reviewed, the minimum rate with an interval of 5 years, whether appropriate, that's not important. Let's see. So we can fix it on the basis of time rate, piece rate, overtime, guaranteed time rate and minimum overtime rate. Okay, so these 4 dates you can remember. Then you will write that it is for different schedule employments is different. for different schedule employment, different classes of work, different kinds of people and different localities. Then minimum wage rate fixed by any one of the following wage periods. So it could be fixed for an hour, for a day, for a month or any other as may be prescribed. मतलब minimum wage जो हम लोग fix करें इतना तो पर मिलना ही चाहिए. वो लोग ने direct amount ने क्यों नहीं दिया? Because for every field and class of work it could be different. Then minimum wage rate should be sufficient where you can get you can get the basic cost of living could be achieved. Now procedure for fixing. So there are two procedures. One is notification method and the other one is committee method. So either you made the committee and the committee recommends us and then we put, or we directly notify that this is the rate. So fixing of the revising the minimum wage. So we are done with this chapter also. Minimum wage mein you fix the minimum wage. That's all. It's very very simple. Revision of rates में क्या लिखा था? That the appropriate government may review at such intervals not exceeding 5 years and revise the minimum wage if necessary. The appropriate government may review the minimum wage so fixed if necessary at such interval not exceeding 5 years. मतलब 5 साल के अंदर review करते रहना चाहिए. Till here it is clear. So till now we have finished which all acts. Just put in the chat box which all acts we have finished. So you will also know हाँ भाई ये पूछा है. And I hope whatever I am teaching, whichever act I am finishing, you are writing in your book short notes so that it is very easy. Just before the exam you will look at it and go. Object of the act has to be known for all. चलो अभी next पे जा रहे हैं हम लोग. We are going to the next act. Okay. Okay. Factories Act, and which is the other one? Now the next one we are doing is the Payment of Wages Act. Very good. Only Factories Act people have written. We've also done the Minimum Wages Act. तो दोनों लिख लेना because ऑब्जेक्ट पता होना चाहिए और एक्ट का ओवरव्यू पता होना चाहिए जो मैं पूरा बता रहा हूं. अब आता है पेमेंट ऑफ वेजेस एक्ट. यू नो पेमेंट ऑफ वेजेस एक्ट है क्या? दैट बाई अगर किसी ने काम खत्म किया, इफ समवन हैज फिनिश्ड द मंथ, पे देम बाय अ सर्टेन अमाउंट, बाय अ सर्टेन डे यू हैव टू पे द pay the wages. So moment the month gets over, after the month gets over, for example I work for Jan, moment Jan gets over, next I should give by when? तो कोई बोलेगा कब तक देना है इनको? Jan 10th, Jan 20th, कभी ये डेट, तो ड्यू डेट दिया है. By when I have to make the payment, and while making the payment I have to ensure that I do not do any unauthorized deduction. चलो भाई ये इन लोग ने ऐसा लिखा है but it is so dirty, doesn't feel like studying. Chalo, let's go to very very good notes. See this notes, so beautiful, feel like studying. So I have made this book and I feel very happy about it. So see, how do you have to present the answer? Piece rate means what? For example, if you're working in a factory and I say you prepare one basket, for one basket 50 rupees you will get. Now you might take 100 hours or you might take 30 minutes. I am fixing on basis of piece. Sometimes I say you make one table, I will give you so much money. I don't see the number of hours there behind. Okay, I hope that's clear. Piece means one product wise. Chaliye, now coming back to the how to present the answer. If you've seen the Payment of Wages Act coming, you will write the introduction and then you'll write the object of the act. So introduction, Payment of Wages Act is a central legislation. The central government has passed a law to regulate the payment of wages, to ensure speedy remedy to them and to them against unauthorized deduction or unjustified delay caused in payment of wages to them. ठीक है, तो ये ऑब्जेक्ट है कि भाई टाइम पे पे कर देना बिना अनऑथराइज डीले, बिना गलत पैसा काटे उसको पैसे दे देना टाइम पे. दिस इज द ऑब्जेक्ट. सो पे द वेजेस ऑन टाइम विदाउट अनऑथराइज्ड डिडक्शन. ऑब्जेक्ट ऑफ द एक्ट. व्हाट इज द ऑब्जेक्ट ऑफ दिस एक्ट? the main object of this act was to eliminate all malpractices which the employers used to do with respect to payment of wages. Okay, so this is it. So against any unauthorized, against any illegal deductions, unjustified this, and to give them speedy remedy. Then coming to the limit, wage limit. ठीक है, कितना पैसा है भाई, किसके लिए अप्लाई होता है? तो द वेज लिमिट फॉर एप्लीकेबिलिटी ऑफ द पेमेंट ऑफ वेजेस एक्ट वाज फिक्स्ड एट 1600 इन 1982. अभी कितना है? टू फ्रॉम 18,000 to 24,000 per month. So what is it? The answer is from 18,000 this has been increased to 24,000. Now see, understand, if I am a company secretary, you are a chartered accountant, for us payment can be done aram se. So many times we give advice to the client and payment comes after long time. Okay, this is very common, payment delays. Now this act doesn't apply to us. I cannot say payment of wages, pay me. It will apply to certain people in certain industries who are earning not exceeding 24,000 per month. So they are earning so less. If you give unauthorized deduction and delay to them, how will they run the house? Okay, ये रहा. आगे बढ़ते हैं. Responsibility of payment of wages. किसकी होगी responsibility? Employer की, employee की? Wage कौन pay करता है भाई, बताइए? Who pays the wages? Who pays the wage? Who pays? Who gives wages? So the section 3 says the every employer shall be responsible for giving the payment. Okay, wage period, by ठीक है, by when we should pay. So every employer shall fix the wage period. No wage period shall exceed 1 month. Means if you go to see such people, I cannot say 2 महीने में पगार दूंगा, 2 महीने का पगार दूंगा, 3 महीने का पगार दूंगा. They will say we will not be able to sustain. Maximum give us monthly payment. Can I say I'll give you half yearly payment? How will a poor person survive? If I give him, you work for 6 months, then I will give you. So the maximum wage period is 1 month. ठीक है? So here also they have given you the maximum wage period is 1 month. Time limit to make the payment. भाई कभी तक payment करना है? So time limit to make the payment, section 5. Okay, it says the wage must be paid before the expiry of 7th day if there are less than 1,000 employees. But अगर 1,000 के ऊपर है, in other cases जिधर 1,000 से ज़्यादा लोग हैं, so I can give by the 10th day. So anytime you go and see in any factory, any place, you will never see payment coming after 10 to whom this is applied. Okay, so if there are up to 1,000 people, 7 तारीख तक payment देने का, but 1,000 से ज़्यादा employed है, if there are more than 1,000, then we'll give by the 10th. Clear? Wage period 1,000 तक है तो भाई 7 तारीख तक दे देंगे if it is less than 1,000. But if there are more than 1,000, then we'll give it by the 10th. Okay, whether in this case shall be paid before the 10th. Now coming to deductions. Now what they are talking about? Okay, the wage to be paid in coins, currencies, because sometimes what happens, these people are there, you give them coins and currencies. Okay, it's fine in both, but you can't give them in kind. Cash में discharge कर दो, account में डालो, coin दो, note दो, चलेगा. Now deductions. Now we are seeing the deductions. Very important. ठीक है? Unauthorized deduction नहीं चलता है ना. Unauthorized deduction is not allowed. So section, what is this? What is this saying? That section 7, deduction from the wages of an employee, allows the deduction for wages in the following. Means employer can deduct the following. If he was fined, absence from duty, there was a loss that he caused to the employer, house accommodation, I gave him house, I gave him my place to stay, recovery of loans, provident fund, income tax cut कर रहा हूँ, PF cut कर रहा हूँ, payments to a cooperative society, deductions, all this is allowed, you can deduct. So that they've given all this can be deducted, or I'll call it as eligible deductions, and maintain a register and records. So the employer shall maintain. Now also one more additional point which you can fit in every answer, that adequate registers and records have to be maintained with respect to whatever it is. Whichever act is there, we have to maintain records and registers. Common point सब जगह डाल देंगे. Now let's go to the next one, Employee State Insurance Act. Next we are doing is Employee State Insurance Act. चलिए अभी हमारे नोट से भी जाएंगे. Let me see which is the next one. Employees State Insurance Act. ठीक है. Now अब ये एक्ट में है क्या सीन, क्या है इसमें, लेट्स सी. ये एक्ट में क्या है. फर्स्ट द ESI एक्ट. अभी सोचो तुम भूल गए, तुमको पता ही नहीं क्या है, थोड़े बहुत तो एक्ट के नेम से समझ में तो आएगा ना, हिंट तो आएगा ना. सो एवरी एक्ट के अंदर तुम्हारा हिंट होना चाहिए कि इसके बारे में क्या लिखा होगा. सो इफ आई रीड दिस एक्ट ना, ऑटोमेटिकली इंश्योरेंस के बारे में बात कर रहा है. इंश्योरेंस, सो इंश्योरेंस होगा मतलब मार लगी होगी. सो SIM, सिम. सो whenever there is sickness, injury, maternity, this act is there to provide for sickness, maternity, injury. So this act, ESI Act, provides for certain benefits to employees whenever they are sick, injured, or they are going on maternal leaves. ठीक है यहां तक. अभी आगे बढ़ते हैं. इसका क्या सीन है, ये हो गया अपना. अभी ये 25,000 और 25,000 फॉर डिसेबिलिटी. चलिए इसमें आते हैं. इसमें क्या बोला है, स्कोप ऑफ द एक्ट. वेरी वेरी इंपॉर्टेंट ये एक्ट आई बिलीव आ सकता है, कोई भी एक्ट आ सकता है. इसका इंट्रो सेम रहेगा, इंट्रो एंड ऑब्जेक्ट. चलिए स्कोप ऑफ द एक्ट कभी अप्लाई होता है. इफ आई एम अर्निंग, तो एक एग्जांपल था, एक बंदा है, इज अर्निंग 25,000, विल इट अप्लाई ऑन हिम? We'll say no, it doesn't apply, because the scope of the act is saying that छोटू मोटू people जो है, okay, who are not earning above a certain limit, उनके लिए हम लोग प्रोटेक्शन दे रहे हैं. So the coverage is at present restricted to employees drawing wages not exceeding 21,000, 21,000 per month. So उनके लिए ये अप्लाई होता है ESI Act. And if they are suffering from any disability, अगर कुछ disability है, so then that limit will become 25,000. So 21,000 and 25,000. ठीक है. Now it applies to hotels, restaurants, cinemas, all these people, wherever they are employing 10 or more employees. ठीक है. Now let's see what next they have given. The contribution. Important. What is the contra to be given? So contra is very simple. The contra is something like this. Okay. Contra, how much पैसा आएगा कहां से? इंश्योरेंस लेने के लिए पैसे तो चाहिए ना, प्रीमियम देने के लिए, तो कहां से आएगा? तो ये कंट्रीब्यूशन इस हिसाब से होगा. मार्केट इज इंपॉर्टेंट. टेक अ स्क्रीनशॉट. Take a screenshot of this, so it is important that the contribution will be, employee will give 0.5% of wages, उसके सैलरी में से कट होगा और उतना अमाउंट प्रीमियम के लिए चले जाएगा. एंड सेकंड, एम्प्लॉयर के जेब से 3.25% ऑफ वेजेस कटेगा. ओके. एंड मतलब टोटल 4% ऑफ वेजेस विल बी कट. टोटल कितना है? 4%. क्या ब्रेकअप है भाई? इनका 0.75 है, तो इनका कितना होगा? 3.25. रिच कौन है? एम्प्लॉयर। तो एम्प्लॉयर ज्यादा पैसे निकालेगा और एम्प्लॉई खाली 0.75 निकालेगा। फ्रॉम वॉट एवर सैलरी का इतना है विल बी गॉन फॉर दिस थिंग, फॉर रिमूविंग अ इंश्योरेंस फॉर देम दैट व्हेनेवर दे आर SIM, सिक, इंजरी, मैटरनिटी, तो उनको मिल जाएगा पैसा। ठीक है, फिर मॉड्यूल में आते आगे कि भाई ये 4% वाला क्लियर हो गया। ठीक है, देन कम्स टू बेनिफिट्स कि भाई क्या बेनिफिट मिलेगा, क्या बेनिफिट मिलेगा, मतलब ये बेनिफिट कब मिलेगा? मेरा तो 0.75 काटा ना आपने, यू कट 7.5%, कब मिलेगा मुझे? सो देन वी विल से दैट बॉस सिक, देन प्रेगनेंसी, मैटरनिटी, डिसेबलमेंट, फिर periodical payment to dependent of insured person, so if you have a dependent also, medical treatment and funeral or death, सीधा ये सब है। तो इफ आई गो, मेरे को चाहिए, मेरा पैसा चाहिए मुझे, तो देन वी विल से आपको ये सारी चीजें होनी पड़ेगी आपके साथ। ओके, देन ओनली आप वहां से विड्रॉ कर सकते हो। अब इसके रिलेटेड झगड़े हो गए, so then we have a quote, employee insurance code, section 74 states that the government shall in the official gazette constitute a ESI court, as a number of judges that will be there. The ESI court will have the same powers of that of a civil court to discharge with all the disputes related to ESI related matters to be decided by the ESI court. Adjudication of dispute, so whenever there is a dispute between employer employee, he will decide. Then adjudication of claim, dispute तो चलो ठीक है, बट claim amount के ऊपर झगड़ा होता है। बोलता है नहीं मेरी इंजरी हुई है, मेरे को चाहिए 2 करोड़, मेरे को चाहिए 2 करोड़, दिस इज व्हाट नॉनसेंस, 2 लाख की इंजरी हुई है। तो अमाउंट ऑफ क्लेम एंड डिस्प्यूट रिलेटेड कैन ऑल्सो बी डिसाइडेड। एक बार मैटर, once any matter related to insurance will now never go to civil court, it will only go to the ESI court. Clear till here? Now we are done with this. We are going to the next particular labor law, okay, which is your Employees Provident Fund and Miscellaneous Provisions Act 1952. अब pay attention, ठीक है? First you need to understand the technique to remember कि ये लेबर लॉ में लिखना क्या है। लोग कंफ्यूज हो जाते हैं, तो इसके लिए क्या है, नाम में ही हिंट है। और नाम में क्या हिंट है, आई विल शो यू। एम्प्लॉइज प्रोविडेंट फंड एंड मिसलेनियस प्रोविजंस एक्ट, ये दिख रहा है, पीएफ का है और मिसलेनियस प्रोविजन मतलब दूसरी भी चीजें हैं, पेंशन, प्रोविडेंट फंड और इंश्योरेंस। In this thing, okay, in this act, Employees Provident Fund and Miscellaneous Provision Act, it provides for 3 schemes. 3 schemes है। बोलते ना मेरे पास एक बड़ी मस्त स्कीम है, तो इनके पास तो 3 स्कीम है। 3 स्कीम है, एक है प्रोविडेंट फंड, डिपॉजिट लिंक स्कीम एंड पेंशन स्कीम। चलो इसका हम लोग इस पे आते हैं, मेरे ब्यूटीफुल नोट्स पे आते हैं, which I have prepared. Okay, hit like for my notes. Okay, and in my notes I also put up some little bit pictures also. Okay, so again, how do we put it up? Introduction. In exam, please write and present in the way I'm showing, okay, the way I'm doing. So this miscellaneous is a social legislation. My English is very weak, मेरी English बहुत ही weak है, but आंसर लिखते वक्त बड़े बड़े वर्ड्स डालता हूँ। You know that it is a labor welfare legislation, it is a social welfare legislation. तो ऐसा डालने का, डे टू डे थोड़ी ऐसा बात करते हैं, but to show to the examiner that you know you have to use this, it is a social legislation. It has 3 schemes. Miscellaneous word मतलब कुछ और भी है, मतलब कौन से miscellaneous? तो एक तो प्रोविडेंट फंड, तो प्रोविडेंट स्कीम होगी, मिसलेनियस में पेंशन स्कीम होगी और इंश्योरेंस स्कीम होगी। ठीक है, 3 स्कीम देते हैं वो लोग। एंड अगेन It is a social security benefit on the workers and their dependents. Such a beautiful line. I can fit it anywhere. So it is a social security benefit on workers. तो लिख देंगे. It aims at social security and timely monetary assistance to the employee and their families. ठीक है, आगे बढ़ते हैं. Once we write this, they have also given na, it's a social welfare, social obligation, etc. Okay, 3 schemes. यहाँ पे भी 3 schemes लिखा हुआ है. Then comes contribution. इसका पैसा कहाँ से आएगा? इसका contribution. Okay. Try to find if there's anything extra to be known. Contribution. Okay. Now there is a detailed calculation in my book, but I'm not going into that. Only little bit what is there for my exam point of view. I've written an entire book on this. Okay, so not going into that. The employee provident fund is a retirement benefit which both the employer and employee contribute equally to the EPF account. Further, employees also receive interest on this deposited fund, which accumulated on monthly basis is however credited at the end of the financial year. The interest rate is determined by the Employee Provident Fund organization in consultation with the Ministry of Finance Ministry every year. ठीक है, तो कंट्रीब्यूशन का क्या सीन है कि भाई ये एम्प्लॉयर एम्प्लॉई दोनों ही कंट्रीब्यूट करेंगे, बोथ विल कंट्रीब्यूट. ओके, and it will be will get interest also on monthly basis, but will be credited at the end of the year, and the interest rate will be determined by the Employee Provident Fund organization. So Provident Fund miscellaneous, so Provident scheme will be there, retirement benefit, Provident Fund organization, ये सब hit होना चाहिए. Then next कि ये इनका अमाउंट कितना है. With effect from 2014, employee on joining the employment is covered establishment and getting wages up to 15,000 are covered to be a member of the fund. तो 15,000 वहां पे लिख दो अमाउंट. ठीक है, चलिए अभी नेक्स्ट पे जा रहे हैं. We are going on the next. See, this photos also I used to have in my book. So good it feels to get a PF. Yes or no? If you want to get retirement benefits and pension funds and this when you retire, like the video. Okay, now moving ahead to the next one is the bonus, payment of bonus act. भाई क्या है ये? What is it? Payment of bonus act. Introduction सब में लिखेंगे. We will show off. 5 mark का question आएगा बस. 5 to 4 marks का भी है बहुत सारे. 4 marks also. 3 and 4 marks. At least introduction will present properly. Introduction. Payment of bonus act. Object of the act. Object and scope of the act. ठीक है? Let's see. चलिए. Payment of bonus act. And इतना छोटू सा है, छोटू सा. ठीक है? Pages can come in this much only. But my point is, I will give you some additional points which are very easy to learn and build your answer. So we will do that. Okay, thoda bahut I will also give extra and you will show. So payment of bonus act. Let's come. First, bonus is not defined, but it means something giving in addition to what is ordinarily received due to recipient. Object of the act. Now you see that for very low income earners, we tend to give certain bonuses. It's a practice that is followed. The object of this act is to provide for payment of bonus to certain employed persons working in the establishment. Have they given you the case law? No. Okay. Now, application of the act, it applies to every factory and every other establishment where there are 20 or more people. It will continue to apply even if it falls below 20. They can ask you a situational question that it was applicable, but suddenly it went down. So it doesn't matter. Once applicable, always applicable. Like Fevicol. Fevicol का जोड़ है. If once it is act is applicable, almost all the labor law. Once if you get into the bracket now, then always you have to follow. Eligibility for bonus. So eligibility is up to those wage earners or those people who are earning salary up to 21,000. देखो, employees drawing a salary of wages not exceeding 21,000 per month. मतलब मैक्स 21,000 कमा रहे हैं तो वो लोग पार्टिसिपेट कर सकते हैं और उनको इस स्कीम में मैक्सिमम बोनस कितना मिल सकता है? 7,000. See, the eligibility is 21,000. So all those workmen, employees who have a salary of 21,000 can get bonus up to 7,000 रुपीज. तो मेरी 21,000 की सैलरी है तो मैं काम कर रहा हूँ तो पूरे साल में मैक्स 7,000 तक मैं ये एक्ट के अंदर क्लेम कर सकता हूँ. फर्दर जैसे मिनिमम तो भाई 8.33% दे ही देना सैलरी का, एंड मैक्सिमम is 20%. So they have set in minimum wage, minimum bonus and maximum bonus. Both have been set. Minimum wage is bonus is 8.33%. Maximum is 20%. ठीक है. Time limit to pay the bonus, again very important, 8 months. Remember this wala point, that bonus shall be paid within 8 months from the close of the accounting year. Okay, so once we have written, we will write the object of the act. Then you can also write this, build it. It's very, very simple. Just to build your answer, okay? Disqualification of bonus. If you had done fraud, you had a rights कर रहे थे, violent behavior, forget right, violent behavior or theft of misappropriation, your bonus can be disqualified. So bonus is given as a conduct good behavior. If you have done violence, fraud, theft, if you like violence, so in that case what happens, you will get disqualified from bonus. ठीक है, यहाँ पे आगे बढ़ते हैं. डिस्क्वालिफिकेशन बोनस. If you like violence, so no bonus. Okay, if you have done fraud, theft, no bonus, because bonus is always given as a good conduct. Next, coming to payment of gratuity. Payment of gratuity act. Let's see what is here. Yeah. So now we'll do the next one. Payment of gratuity act. Let me just have a water break. Just 2 minutes, I'm coming back. Okay, and for those who have not yet hit the like button, I think you're waiting to smash the like button. So go ahead, like the video. Feels good to have more likes. Okay, then let me have water. Okay, so now I'll increase the speed and go really fast. Okay, so coming to payment of gratuity. Gratuity is a lump sum payment. It's a retirement benefit. Okay, then gratuity is given if you work continuously for a period of 5 years. And this act is super important. 5 years. If you work, you will get this money in case of superannuation, retirement, resignation, or disablement. Okay, so D, Doctor S, whatever you can remember. Superannuation is like a compulsory retirement, voluntary retirement if you've resigned, or death. So in all these cases, gratuity is available. However, in case of D square, in case of D square, here the 5 years is not necessary. 5 years of continuous work is not necessary. Again, so if there is a superannuation, there is a retirement, resignation, all these cases you will get your gratuity. Gratuity is a lump sum benefit for retirement, provided you work with the company for 5 years. However, if there is a death or disablement, then you don't necessarily have to work for 5 years. Then this is about payment of gratuity. Coverage, it covers all those. If you don't remember all this now, just remember it covers all those industries prescribed in the schedule, prescribed in schedule of the act. सिंपल सा लाइन लिख के छोड़ देने का, ठीक है. Then they have given the 5 years provision when all you get this. Then they have said given the maximum amount of gratuity that you can get is 20 lakh rupees. So if I go here, the maximum gratuity that you can get is 20 lakh rupees. Then Employee Compensation Act. Employee Compensation Act. Now Employee Compensation Act, let's go to that. Now Employee Compensation Act is there. It's a social security. Anyone who, so compensation can be given if you suffered any kind of a disablement, okay, or there is an accident, you will get compensation. Now object of the act is, it's a social welfare legislation, social security legislation, will pay compensation on disabilities or diseases that you've got during your employment. Now there could be partial or total disablement, and on disablement or death you will get compensation. Now the compensation amount is given. The total amount of compensation that you can get, in case of death you will get 1,20,000. You will not get, your legal heirs will get an additional funeral expenses of 5,000 rupees. In case of total disablement, you will get 1,40,000. So total disablement is going to be continuous recurring expenses for you, right? So in that case 1,40,000 will be given. Okay, next if we go to okay, next we go to this part. We've done with this. Then comes contract labor. Very, very important. Yeah. Now, contract labor. Okay. Now pay attention. What is the meaning of contract labor? Many people don't know the meaning of contract labor only. Okay. So contract labor is, there is a employer. He has hired a contractor. The contractor has further hired certain persons. These persons will be called as contract laborers. Contract laborers. So law says that the contract laborers who are there, okay, they are on the, imagine Mukesh Ambani is there, they appoint a contractor. The contractor has those people who are staying on the streets, etc. They require drinking facilities, safety, etc. If they don't get their money from the contractor, they can claim it from the employer. This employer, if he had to pay the money, he can recover it from the contractor by way of a loan. He'll say that I have given on your behalf, I'll take, or as a deduction from the employer's fees. Okay? So first contractor has to give, but if the contractor is not given, then the employer has to give. Okay, and they have to give facilities such as canteen, restroom, first aid, drinking and washing facility. Okay, Industrial Dispute Act. So now we're going to Industrial Dispute Act. Again, you will write the object of the act. Industrial Dispute Act is provides a machinery for peaceful resolution of disputes, promote harmonious relation between employer and employee. So proper peaceful relations होने चाहिए between employer and employee. For this we have this law. Object of the laws, object and significance. As per the Workman T versus this Supreme Court judgment, it is said that the object of this act is to settle disputes between employer versus workman, or workman versus workman, or employer versus employer. Okay? So any kind of industrial dispute can be taken up under the Industrial Dispute Act. Then dismissal of a worker deemed to be a industrial dispute. See, this part. Individual dispute. Let's say if there is some personal reason that they are fighting, so it is not an industrial dispute. But if there is for conditions of work, condition of contract, even one person के साथ issue हुआ, it can be treated as a industrial dispute. So it was held that if there is a dispute between the employer and an individual employee, but the topic on which they are dealing, the subject matter which they are dealing is relates to a community of interest, relates to the benefit of all, then it will be treated as an industrial dispute and not as a personal dispute. For example, if I go and tell that मेरे को safety नहीं मिल रहा, I'm not getting proper safety, or we are not getting any proper safety, though the dispute is in me and the employer only, but I am talking of a matter which affects everyone, it is an industrial dispute, even if the individual dispute can be treated. Yeah. Then dispute can be settled through arbitration here. Also, the arbitration agreement, etc., will be there. These alag tribunals are there to settle the disputes. Now, from prohibition of strikes and lockout, this is very, very, very important. Prohibition of strikes and lockout. Now, when it comes, see, now let's see. Very, very important, so pay attention. Okay? Strikes and lockout. Strike and lockout. Strike and lockout. So we're coming to my notes. Yeah. So let's understand. Prohibition of strikes and lockout in public utility service. Very, very important. Public utility service is, now in the past exam also they have asked a question that someone is in the electric board, they all are going, or some BMC for water, drinking, sanitation, a municipal body, or a banking sector wants to go and strike. So they are into the public utility service which affects you and me also, all the people. So when that sector wants to strike, they have to give a prior notice. If without the notice they go, it is a punishable offense. So no person employed in a public utility service shall go on strike in breach of the contract without giving proper notice within 14 days before the expiry of the date specified in the notice, during the pendency of any conciliation, or and no person shall declare lockout also. No employer shall declare lockout. So this is important. Okay, you can read it. I'm telling you, this comes in the exam. So understand what it is. So all of this is important. Okay, what are illegal strikes, illegal lockout, etc. So what happens? Strike is done by employee, and lockout is done by employer. Okay, so both of them cannot do in public utility service. So if they are engaged in the business of public utility service, they cannot do a strike or lockout. Trade unions. So they have asked in the past exam also question. Let me go here and check for trade union. Trade union. See, the logic of trade union I'll just show you in short. You will see one picture and will be done. See, normally a employee doesn't have strong power alone, but when they come together, form a trade union, register it, then they can have a stronger power. So this is a means of collective bargaining. The strong way of bargaining you can do if you gather together. Now इसमें क्या होता है ट्रेड यूनियन में? What is a trade union? Introduction you will write. Trade union is a voluntary association of workers to promote, protect their interest and welfare by taking collective action. The legislation regulating trade union is the Trade Unions Act 1926. Now modes of registration. Okay. Now is your modes of registration. Yeah. Now modes of registration of this. Okay. Now if you go to see that there are specific trade unions of specific companies. HUL trade union, Reliance trade union means उस company related भी specific trade unions होते उसी company के workers की. So a trade union may be formed. They can apply. No trade union workers shall be registered unless 10% or 100 workmen, whichever is less, are engaged and employed in the establishment are employed in the establishment with which it is connected are the members of the trade union. Understand? अगर Reliance की बात कर रहा हूं मैं, if I'm talking of Reliance employees can only make employees will make a trade union. So at least 10% should be employees of Reliance or 100, whichever is less. So even 100 employees of Reliance can make a Reliance trade union. They will give an application form with all the details, who will be the office bearers, how they plan to take contribution, etc. Then they will have a certificate. This trade union will be a separate legal existence and can hold property, etc. File cases in its own name as well. Okay, so we are done. Modes of registration. कम से कम 10% or 100% should be employed in a company with which is there to set up the trade union. Application will have to be given by 7 or more people. Okay, same like how you set up a public company. Shall be accompanied with the rules. Okay, then you will get a registration certificate, and always you will write it is, you can file returns as well. Maternity Benefit Act, very very important. Maternity benefit. So women get this benefit. The Maternity Benefit Act regulates employment of women wherever they are employed in establishment and there are 10 or more people. Now what benefit do they get? They get a maternity paid leaves. They get paid leaves. Okay. So as per the Maternity Benefit Act, maximum period for which a woman can get paid maternity benefit is 26 weeks. So 26 weeks they get a paid leaves up to 2 children. For adopting mothers, for more than 2 surviving children, 12 weeks of paid leave is also available. So in case if there is an adopting mother, so we want to promote adoption also, so that there are people who might looking for parents. So for them we say, okay, fine, if you have 2 children, but if you are adopting, you get 12 more weeks of paid maternity leaves. Now coming to Children and Adolescents Labor Prohibition and Regulation Act. From the name itself, this is an act to prohibit working of children in any establishment. To prohibit is there. And for adolescent is above 14, below 18. So below 14, not allowed to work in any factory, any place. But if it is above 14 but up to 18, this range, that adolescents can work, but it has to be in a safe environment. Below 14 years, can I make a child who is 3-year-old, 4-year-old work? Answer is yes. Now it is allowed. Nowadays you go and see these children, they come in all these television serials and all those ads for this, that Johnson and Johnson. They come, they're very chill, they're young, they are working, they are earning very well. They are coming in movies. So they can earn, but there are exceptions when below 14 years also you can employ. Let's see. Is enacted to prohibit engagement of children in occupations and prohibit adolescents working in hazardous occupations or processes. Now this is with a convention that was held by the ILO. Now it prohibits employment of children in occupations or processes. No child shall be employed. This except, now this is where you can employ a person who is below 14 years. कहाँ पे करोगे? Family business चलता है. अगर ऑडियो विजुअल एंटरटेनमेंट इंडस्ट्री चलता है, फिल्म्स, टेलीविजन, तो यू कैन एम्प्लॉय, दैट्स व्हाई दे आर वर्किंग. And however, it shouldn't affect their school education. Now they're saying processes, hazardous processes में you cannot keep adolescents, very dangerous, like mines, inflammables, hazardous. These places are given in a schedule, you cannot employ them there. Hours of work of adolescents, no adolescent shall be required to work. अब जो भी normal people काम करते हैं ना, उसका आधा, whatever the normal people work, half of it. So shall be required to work in excess of the number of hours prescribed, shall exceed 3 hours, and no adolescent shall work for more than 3 hours with an interval for at least 1 hour. The period of work of the child shall be inclusive of his working hours. It shall not spread over 6 hours during any day. So just important, just read it. They can ask you what is the period of work and number of hours. No adolescent shall be permitted to work in the night. Okay, रात में they cannot work. So night shift not allowed. Night shift not allowed. No adolescent shall be required to work overtime. No adolescent shall be permitted to work in any establishment on any day which he has already been working in another establishment. He's worked in one establishment and on the same day he wants to work somewhere else. So these are the important sections. Holiday he will get, obviously. Adolescent employed in establishment is entitled in each week a holiday of at least 1 whole day. Okay. The notice, there has to be a notice telling that which day he will get holiday. Notice to the inspector. So every occupier who is who employs any adolescent, तो बच्चे को रख रहे हो तो बताना पड़ेगा इंस्पेक्टर को कौन है, क्या है, क्या काम करा रहे हो, all those details, and maintain a register of what all work you have done, and it will be displayed on a conspicuous part of the place. सब देख सकते कहाँ पे है. पेनल्टीज भी है. पेनल्टीज एक बार रीड कर सकते हो. They can ask. They're saying if parents do something wrong, so no penalty will be there. Not much penalty. Okay. Rights of persons. Now rights of persons with Disabilities Act 2016. Now this act is where specifically for people who have disabilities, a kind of a disability. Now they've given you different kinds of disabilities here. Blindness, okay, 7 categories of disabilities I mean here. Blindness, low vision, hearing impairment, okay, disability, locomotor disability, movement disability, retardation, mental illness, leprosy. So all these are persons who have disabilities. It is our duty that we give them proper safety, employment, treatment, no discrimination should be done. So here we see the fundamental rights will also come. Okay. Now we'll see the fundamental rights. We'll see in some time when it comes. Remember, we want defines persons with disabilities having at least not less than 40%. Matlab, at least 40% of these 7 categories you have, of these 7 categories, 40%. It doesn't have to be permanent blindness. Little bit also 40% blind I am, so or more than that, you will get benefits under the this act. Important definitions is not really important. Still, what all rights do they get? Important, okay, that they should be treated equally without any discrimination. The government should ensure that workmen and children with disability are enjoy equal rights. Okay, they should be able to live in life with dignity in and live in community also proper. And one more point I want to show that these people have this fundamental rights. So you can write it. Article 14, right to equality. So equality means a proper classification we are making for them so that they get certain benefits. Equal employment they should get, and there should not be any discrimination. Articles this says that they shall ensure that there is end to cruelty and inhuman treatment from them to them. Okay, the government should take measures to protect the persons with disability from any sort of abuse or violence. Shall protect and safety with disability in case of any risk of armed conflict, etc., emergency, natural disasters. So if tomorrow there is a war, etc., or any riot, so we have to take कि भी इनका क्या करना है, how do we protect them, take them to a safer place if there is natural calamity, etc. Deals with family homes and family rights. If there is any separation, nowadays we have to think for that also. How we have a old age home, we should have proper state government should set up certain NGOs for this. Now provisions relating to education. Okay, so this is past exam question, that we should give them proper, state government should admit a person with disability without any this discrimination, make a building or a campus which they can access, support children, make arrangement for students who are deaf and blind, to make provide for transportation facilities, to provide inclusive education. Inclusive means even they should be coming and getting a good chance to learn. Make a following provisions. They can make surveys from time to time if they have special needs. Establish schools, provide books, give them scholarships, and give them R&D to improve both teaching and learning skills. So this is important. Skill development. We should work towards their skill development and have certain skill development programs. Give them adequate support for specific kind of training. Loan should be given to them. Marketing the products made by them. We see when they make certain products, we market it. Maintenance of data about the progress that has been done in these development schools. Social security. Social security means mental health, family, all the society should be there. So they should have certain community centers where they can go and play, mingle. Facilities for persons including children with disability who have no families. Support the person with disability. Okay, support women and to make livelihood, ensure safe drinking water, insurance schemes. Okay, so you can read it up. The responsibilities of the state government important. So everywhere you see the state government shall ensure, shall conduct, encourage, shall provide access to information, shall ensure that they get proper all these impart training, specific needs. believe we are done with it. Okay. Now the last act, and then we'll wrap up for the day. That is the POSH Act. Okay, so this is the last act, and then we are wrap up for the day. POSH, which I feel is very, very, very important, and it can come in exam, and it is a past exam questions also. POSH Act में है क्या? Every establishment where there are 10 or more workmen. So first, sexual harassment is a violation of fundamental rights of Article 14, Article 15, discrimination on the basis of gender. Okay, and Article 21, they cannot live a life with dignity. So we have to give protection against sexual harassment. They've given you few definitions. In the definition of sexual harassment is important. What amounts to sexual harassment? Means the following unwelcome acts. So where you are having physical contacts, a demand, showing any kind of wrong things, making certain remarks, etc. So this you can mark as important. They can ask you. Workplace means wherever you're working, any department, government or non-governmental. It is a duty of the state to ensure that we are protected. Okay, there is a prevention of sexual harassment. Now the most important part which ensures that there is no sexual harassment is the internal complaints committee. Every employer shall constitute a committee to be known as internal complaints committee. Matlab, every employer should have this committee. So wherever there is any woman, she wants to go and complain, she can go and complain in this committee. Who will be there in this committee? Very, very important. A presiding officer who shall be a woman. Not less than 2 members from an NGO, okay, of a women who have a past experience in a social work. And lastly, 1 member from an NGO as well, who is familiar with the issues relating to sexual harassment. And at least half of the total members shall be nominated will be women. Complaints can be given. So any aggrieved women may give a writing letter to the complaints committee. In case it is not constituted within a period of 3 months from the date of incident, in case of series of incidents within a period of 3 months from the last incident, you have to go and complain to this committee. Conciliation. So now sometimes it might be not very serious kind of things where they want to settle it between them. We've seen between there are a lot of settlements also. So here also conciliation can become a middle path, can be done, that the person promises that he will not do anything and he is really guilty. So in such case, they will inquire into the complaint, and they will have reports also by the internals committee, and they will see that if it is it has been repeated series of offense or no. Very, very important. Duties of the employer, they can ask in exam. Now what is the duty? Very simple. They will ensure that there is a safe working environment. It is all this is displayed. You will organize workshops and awareness programs, provide the necessary facilities to the internal committee, assistance securing attendance of the witnesses, make available information to the internal committee, provide assistance to women, initiate actions under the Indian Penal Code, and treat sexual harassment as a serious offense and monitor the timely submission of reports. So that is it. We've completed the entire chapter, which comes for around huge weightage. Okay. Now, so for you, I have covered properly all these things. Okay, what I have covered from 25 marks I've covered in depth. Okay, and then I've covered a really big chapter which will confirm come in your exam for around 11 marks. Okay, that is there. Now from part A. Okay, industrial environmental laws, just YouTube it. I have made this public, where you just put environmental laws CS executive, my video will pop up. Okay, this is it. Even for I think this intellectual property right, I will just unlock it, so that next time now you put IPR CS executive, my video will pop up. After the your exam, I will hide it back again. Okay, now from the part A chapters, तो B C का तो sort out हो गया, खाली एक और initial registration licenses का है scene. Now setting up of business entities. From here, what you need to do, types of all this will be covered in your company law. Startup will come a lot of marks. Okay, इसका weightage है, the NBFC का weightage है 7 marks. This, that is it. Types of companies as it is you can attempt. Okay, so I think more or less you're sorted. Even this has been covered. If you're giving both the groups in EBCL, this will be covered, the 11th chapter. So that is it from my end. Wish you all the very best. In case if you need any help, do let me know. Do join our Telegram groups, WhatsApp groups, download the app. Okay, and for your group 2 also, after your exams, I will be conducting the lectures, etc. So you can contact us for that as well. Okay, wish you all the very best. I did my level best, how much ever I could. Okay, so rest I believe you can easily pull off. In case if you get stuck anything, please do let me know, and please mention like the video whenever you watch it, and put in the comment section also good comments. Thank you so much. Wish you all the very best. See you.